Okay. Good evening and welcome to the February 28th meeting of the St. Mary's County Planning Commission. There are two sign-up sheets in the foyer for our hearing. One is a sign-up sheet if you're speaking this evening. The other is a sign-in sheet for attendees of this hearing. In either case, in case any further information needs to be sent to you regarding these cases, please sign up on the sheets. Also, when people call in tonight, we will take their address down, and if any information needs to be sent to them, we will also make sure that they get that. Our meeting is being recorded this evening for the public record. Any comments made by anyone present must be recorded as part of the record. Therefore, if you have anything to say, you must come up to one of the microphones provided. Your comments cannot be recorded and placed in the record unless they are directed to a microphone. You are to direct your statements, questions, or responses to the board only, and we will direct them to the appropriate person for an answer. Please keep your comments to 5 minutes or less. Anyone testifying or asking questions during our public hearings will be required to take an oath, and that also anybody calling in for public testimony on the phone. And we thank you for your cooperation. Also, would you put your cell phones on silence if you could? On our agenda this evening, after a a review and minutes of February 14th, we have two public hearings. First one is MSUB 21-0058 for the Brickhouse Farm Subdivision Family Conveyance. Following that will be number 13-120-004 for the Woods at Myrtle Point, Section 3 of a major subdivision, following by adjournment. I'll let the board members introduce themselves. We're going to start different this time. We're going to start with Mr. Evans down on the end. I slighted you this evening. We're going to let you go first, Mr. Evans.
Merle Evans.
Joe St. Clair.
Joe Van Right.
Thank you, Mr. Vancouver. Howard Thompson.
Patty Robrecht.
William Hall.
Summers.
Sorry about that, Ms. Summers. We'll go back to normal next time. Okay, also with us from county staff, we have the Director of Land Use and Growth Management, Mr. Bill Hunt, his planners, Courtney Jenkins, Brandy Glenn, and Nick Colvin, and also their administrative coordinator is Kimberly Wood. Our supporting county staff, just make sure it's here, Mr. Neil Murphy, our Deputy County Attorney. From the St. Mary's County Metropolitan Commissioner, Mr. Andy Balkin is with us through Zoom. Also through Zoom is Mr. Donald Mills, the Deputy Director of the Department of Public Works and Transportation. And our most important person is Amy Carter, our video media producer for this evening. Okay. Did everybody have a chance to review the February 14th minutes? Are there any corrections, deletions? If none, I'll accept a motion to approve them.
I move to approve the minutes of the 14th February 2022 Planning Commission meeting.
Do I have a second?
I second.
Yeah, a second by Ms. Summers. Okay, go down the roll call. Mr. Hall?
Aye.
Mr. Van Kurt?
Aye.
Ms. Summers?
Aye.
Mr. Evans?
Abstain. I wasn't able to vote.
Okay, Mr. Evans. That's all right.
Say Mr. Evans.
That's all right. I know where you're coming from, though. Mr. Evans.
See what happens when you start down here?
Aye.
You both answered at the same time, so
Okay.
I heard his, didn't hear yours. Okay, and I vote aye also. Moving right along.
It's not going well.
Aye.
Oh, I'm sorry, dear. I had an M beside you. You're the motion person. Okay. All right.
We need to reset.
I'm doing the best under pressure here. Okay, we will go on with the first case of this evening. Bring this up. That's for a minor subdivision. Number MSUB 21-0058 for Brickhouse Farm Lane. Owners James and Lois Owens. They live on Windy Way in Hollywood, and their action requested is a preliminary review of one additional lot on a private road in accordance with the St. Mary's County Subdivision Ordinance 10-01, Section 30.14.4 of the Family Conveyance Provision.
Do you want to swear us in?
Excuse me?
You want to swear us in?
Yeah, I was just seeing who's going to be here. Everybody that will be testifying for this case tonight, if you would stand at this time, and I'll get you sworn in. Anybody that calls in while we're doing public testimony, I'll swear you in as it comes. Okay, if you raise your right hand, and do you declare and affirm under the penalty of perjury that the testimony, responses, and statements you may give will be the whole truth and nothing but the truth? I do. Okay, thank you.
Okay.
Okay, Brandy, go ahead.
Share my screen real quick. Okay, good evening. Agenda item 1 is minor subdivision M sub 21-0058 Brickhouse Farm Lane subdivision family conveyance. The site is located at 43525 Windy Way, Hollywood. The land use is rural preservation, and the zoning is rural preservation district with an AE4 overlay. The minor subdivision seeks approval of one additional lot on a private road in accordance with St. Mary's County Subdivision Ordinance 10-01, Section 30.14.4, Family Conveyance Provisions. The public notice for the Planning Commission public hearing was published in Southern Maryland News on February 11th and February 18th. The property has been posted in accordance with CZO requirement section 21.3.3. Certified mail receipts have been received and have been entered into the record of this public hearing as Exhibit 1. The agenda was posted on the website on February 23rd. The minor subdivision was reviewed at the TEC meeting held on June 23rd, 2021. The proposed Lot 1A will be the 8th lot on Brickhouse Farm Lane and Windy Way. Currently, there are 5 lots under 15 acres on Brickhouse Farm Lane and 2 lots under 15 acres on Windy Way, for a total of 7 lots under 15 acres. Per the subdivision ordinance, section 30.14.5.c, all subdivisions except farmsteads and lots approved through the family conveyance provision of this ordinance proposed with 8 lots or more shall be served by public roads. The total number of lots under 15 acres and farmsteads having access to Windy Way and Brickhouse Farm Lane are 12. The sale or transfer of lots for family conveyance purposes are limited to the property owners of record on or before May 25th, 2004. James and Lois Owens have owned the property since September 16th, 1995 per deed, Liber 998, folio 384. The proposed lot will be conveyed to their daughter, April Renee Owens. Per the surveyor's letter dated February 3rd, 2022, I quote, "The existing road has an existing R20 paved entrance off of St. John's Road, is well kept and varies from approximately 12 feet wide to approximately 13 feet wide, including shoulder, and is asphalt for the first 1,330 feet and gravel for the remaining 700. We believe the road is adequate for an additional user." There's a few pictures here. Mr. Owens has maintained the road from Windy Way to St. John's Road since 2011, end quote. Got a couple more pictures. This concludes the staff's report and is entered into the record of this public hearing as Exhibit 2. Representing the applicant is Barry Vuckmer with Chesapeake Trails Surveying and Chris Longmore. Do you have any questions for me?
Does anybody have any questions of staff at this time? I'm sure we'll have some for you later.
Okay.
Randy? Okay. Okay. Who's coming up for the applicant?
Actually.
All right.
Good evening, Chris.
Good evening. Thank you, Mr. Chairman. Thank you, members of the commission. Chris Longmore here on behalf of the applicant, Mr. and Mrs. Owens. Tonight, we plan, Mr. Vuckmer is the surveyor on the project. He has some PowerPoint slides he's going to present for you. And just a couple of initial points, for us to make. We are here on a family conveyance subdivision, which is a little bit unique in our ordinance. A few of the opening remarks I'd like to share is that this ordinance was designed to allow people that own property at the time of two zoning ordinances ago to be able to give lots to their family members. And it was done in a very narrow way. You had to own the property in 2004. Anybody who bought it after that did not have the rights to do this. And it was really, I believe, a compromise between some of the landowners and some of the new zoning regulations that were going into effect that were limiting people's ability to do that. Our client meets all of those objective criteria that would be needed for this. They've owned their property since 1995. We think it's a very appropriate request that they have. I'll be happy to summarize after Mr. Buckmer's talk, and we'll be happy to respond to any comments from the public as well. But I'll turn it over to Mr. Buckmer.
So as Ms. Glenn said, we prepared a minor subdivision plat in June for submittal that's been approved by all the appropriate agencies. We do believe that the road is adequate. We had some tech problems with my slideshow. So if you have any questions, we can go back to the county slideshow.
Okay.
I'm gonna see
Could
if
you
I can.
pull yours back up?
Oh,
Randy?
yeah, I can do that. I can also see if I can bring the subdivision plat up, but I can bring mine back up. That's no problem.
So my slideshow consisted of basically the same thing with the photographs that I had sent into land use. And it had a overall aerial in it where you could see the driveways that were, that came onto Brick House Farm Lane. Could you go to the third slide?
Sure.
Randy, I think that shows that.
This one? You want the pictures or this?
No, that's fine. So if you can see where the blue dot there, that is where the proposed lot is. The outline of the boundary is not correct. Mr. Owens Farmstead actually, the boundary extends to where Brick House Farm Lane intersects that northern boundary. If you could highlight that, Randy.
Like right in here?
Yes, right there, yeah.
Kind
yeah.
of like this.
So the lot is generally in the area of the blue dot.
Do you want me to go to the pictures?
You can, but they've seen them already. So
Okay,
I think-
all right.
Mr. Owens is here too, if you have any questions for the owner.
I have a question, Barry.
Yes,
If
sir.
it's time for that, since you're not providing any additional. One of the comments was from the O'Grady's. And I'm not sure if they're here calling in or whatever, but they made a comment that the Brick House Farm goes through their property
That's correct, yes,
to
sir.
get to this property.
Yes, sir.
I'm assuming that's a recorded
It is, yes, sir.
easement through
Yes, sir.
there. And, I'm not sure how long the O'Grady's had been there, and I see them, Mr. O'Grady had raised his hand to speak, and maybe a question I asked him was that, it was already there when he purchased the property, or had they been there a long time? I'm not sure. And we can get to that when he's able to speak, but it's previously been there. It's not an extension of Brick House just to get to another lot.
That's
I mean,
correct.
it's been there like that.
That's correct,
Okay.
yes, sir. Yes, sir.
And I have a copy of a plat that I can submit for the record.
No,
to
that's,
show.
I would assume it had been by being on there, but just wanted to
I
confirm.
believe it was 1995 is when the plat was recorded. It was
Okay.
an NGO plat in the original
Okay.
subdivision. So I'll be happy to submit that for the record. I'll step back and grab that.
So the plat that created Mr. O'Grady's lot was Farmstead B2, and it was recorded in 2015. Actually, the record date is, yeah, I can't see it there.
Yeah, there's on Mr., I guess the best way to describe it, on the plat that Mr. Vuckmer has submitted, there is a reference to a 40-foot right-of-way that had existed since the original subdivisions on these piece of properties. It was an NGO plat that is recorded among the plat records in 1995, I believe, is the date of that plat. So there's been a 40-foot right-of-way there. There's been other lots created since that was there, but it's been there since the original subdivisions on the property.
The 40-foot right-of-way ran all the way up to the lot that they want to add under the family conveyance. Is that
That's right.
where it stopped as it shows?
Yes, sir.
Okay.
Let me ask a question.
Is there any, go ahead, Ms. Hall.
Just for clarification, it's my understanding that currently the road is a private road,
That's correct.
but if you have an eighth lot, does it then need to be a county road?
So the subdivision and zoning ordinance have provisions that once you get to 8 lots, it has to be upgraded to a county road, but there are 2 primary exceptions to that. One is the encouragement of farmsteads. You can have an unlimited number of farmsteads on a private road in addition to the 7 base lots. So that's number one. That does not apply tonight. The second exception is this family conveyance provision where the ordinance expressly says that you do not need to upgrade to a county road only for family conveyances. And the family conveyance can only occur if you convey it to a specific family member. They list the relations in there. I know spouses and children are included in that. In this case, it's our client's daughter that's doing it. They also had to own the property as of 2004, May 25th, 2004. So anybody that's owned their property that long that wants to convey a lot to their child or to their spouse or other enumerated family members is allowed to do that on a family road, add a new lot on it, and go beyond the 7 lots that would otherwise be allowed. Those are the only 2 exceptions I'm aware of to requiring a public road.
Is there a time limit, Mr. Longmore, on the amount of time I'll say the daughter would have to own that lot or keep that lot?
There are restrictions on it, and I can have staff correct me if I'm wrong. I believe it's. I
think it's 5 years.
At least 5 years that's the date that the ordinance, that I recall in the ordinance. So they have to at least do that. I've had other clients that have had to actually get the restrictions removed from their deeds and go into court to do it or come to the board or to the planning commission at times. I think it was the Board of Appeals. But on this more modern provision, it's 5 years at least that it must remain within the family.
Let me ask one more follow-up question, just for clarification, because might not have known this. When Ms. Summers asked you that question, you said when the 8th lot is created, it would have to go to the county. So it would come, has to be, I always thought it just had to be upgraded to the county standards, but then it would still be turned over to the county?
No, that's good. It has to be upgraded to the county road standards.
But it would still be a private road?
It could be, or it could end up getting turned over to the county in certain circumstances, I'm
Okay.
sure. But it has to be upgraded to those county road standards at that point.
Who would say whether it's got to, not in this case because it's a family conveyance, but who would say in the normal if it had to convert to the county or just remain private, upgrade it to the standards of the county?
I don't know how that decision is made specifically. What I've seen in some of the clients that I've had that have applied to add lots onto a private road, they cannot get the minor subdivision approved until they prove it'll come up to county road standards. I don't know how the county makes the decision of when they want to pull it into their road system.
Thank you for that clarification.
Is there any other questions? The applicant?
We will note a couple of things that are in the application. There's all sorts of private roads that are out there in the county. We've all seen them, I'm sure. I've had other clients that have had them. So a couple of things that are unique to this one are that the majority of it is paved, not all of it toward the end, but over 1,000 feet of it, I believe was in the staff report. It does have that entrance that was described, the R25, I think, entrance that is a good entrance with good sight lines, as you could see from the photos. And Mr. Owens, our client, is the one that has actually maintained the road for a considerable amount of time. Barry might know the exact time, or Mr. Owens can, from his property all the way up to St. John Road, where the private road ends. So when it comes to the quality of a private road, this one is a lot stronger than others. It's also a relatively flat area where the road is located, with not a lot of deep ditches or slopes on either side. So we think it is a really safe road. And again, they're only asking to add one more lot on the road and enjoy the family conveyance provisions that the ordinance really sets forth are exactly the type of case like this where they're provided for. So people that own property in 2004, when they put these provisions in effect, my recollection is it came in a couple of years after the 2002 zoning ordinance, because a lot of people were concerned they could not give their children lots at that point. The county commissioners balanced that and decided if you own your property already, we're going to let you convey lots to your family members and not have to go to the incredible expense to upgrade the roads up to county road standards when it's one lot at a time. So we think we fall right in that. We appreciate it.
Mr. Chairman,
Yes.
is there a road maintenance agreement?
There are. I'll note on, and Mr. Vuckmer had pulled all these on board docs, and we'd ask that all the documents on board docs be made part of the record. I believe there's at least 5 or 6 road maintenance agreements that Mr. Vuckmer pulled from land records that are all recorded against it. Our client, if this subdivision is granted, will also be required to record a road maintenance agreement to agree to participate in the maintenance of the road. That's required under the ordinance, and our client is willing to do that. That will have to be approved in form and substance by the county at the time of the recording of the subdivision lot, if you approve it. So that will be something that'll be required. It'll have to have the restriction that the family cannot convey it outside of the family for the specified period, and it will also have that provision that it needs to have a road maintenance agreement. So the road already has 5 of them recorded against, and there'll be another one when this lot's created if our client is approved.
Without looking at the road maintenance agreements, is there a single entity that's in charge of that says it's time to do the maintenance on the road, and
Yes,
how do they
so
collect?
these things are often done hodgepodge. So you start out with a 2-lot subdivision, they add another lot, so there's a new maintenance agreement that's done. So typically, the way we approach that is instead of redoing the road maintenance agreement each time, we just add a new one, and we do. So the new agreement would say that they're responsible for 1/13 of the maintenance. We set up a board each time. I don't think that's exactly what they call it. Association. And it gives dates when they're supposed to meet, but typically they're not followed, to be honest. You know, they just do a collection and fix the road.
Yeah, I mean, what
Not sure that they're actually enforceable in strength.
Yeah, what I've seen happen over the years is that this is an agreement that has been approved and formed by the county. You all may have seen them in their own board docs. You can see several of them on there. When you create 1 or 2 lots at a time, the county requires those to go into effect. What that does allow the other users to do is it's a written obligation that's recorded that if you're not doing your share, they can enforce it if they want. Not everybody always follows it to set up an association or vote or do all that. But there are instances that I've seen in my practice in other areas where someone's not contributing. You can use these agreements to say you agreed to do that when you got your lot, or your predecessor agreed to do it. You're now obligated for your share. So they can be enforced, but they're not done in the way that was suggested, where sometimes when you do a subdivision of lots all at once, you may create an association and create one agreement that covers all the lots. In practice, with these single lot subdivisions, over time, the county came up with this mechanism to allow these to go through and still ensure that those new lots have to pay for their share. So that's really the county form that's on the county website.
So that's the reason for so many,
Right.
okay.
Mr. Chairman, I have a question. Yeah, so the one thing is consistent about agreements, those agreements, is there's no consistency.
Right.
They're not consistent.
Yes, sir.
And you can see that these aren't anywhere consistent.
Right.
The thing that concerns me, I mean, I don't have an issue with family conveyances. It's a great tool. But over the years, having sat here for a while, there's never an issue with road maintenance agreements until there's an issue with the road. And then people start scurrying around trying to figure out who's going to pay what, how we're going to pay, and then it becomes very litigious, and attorneys get involved and the rest. And I don't know really what to do about that, although I've seen some that are so loosely done. And in these cases here, a lot of the blanks, a lot of those, are just blank. There's no percentages, there's no numbers, there's $1 in one and there's none in the other. And the association's supposed to collect the money so that when it's time annually, that it gets done, and apparently that's not done here either. Is that generally how you see that across the county?
Yes, to a large degree. I mean, when a neighborhood or a certain member of a road, an owner on a road does not agree to do their share, it really does turn into a dispute if you need it. I think the only other alternative would be to create an agreement that everybody signs each time there's a lot created, which is just unworkable and would not.
We're not going to do that.
Would not be possible legally or otherwise. So these, I think, are the balance, the best you can kind of do, I think, in saying that if you get a lot here, you're going to have to agree to be obligated to pay your share. And this is an agreement that, in the other legal work I do as an attorney, I can go in and say, look, this person agreed to do their share and they're not doing it. There's a clear intent here to be part of the maintenance of this road, and it can work. Of course, it turns litigious if people don't work together. A lot of times, I rarely see those go into court or go that far into court, because usually people realize it makes more sense to work it out than to spend all the time or money to fight over.
And the other things about these private roads is that, and I don't know exactly, this roadway, I was there today and just went in just for a while, but it's about as wide as my driveway. So those folks need to get along. You don't get along, there's going to be a problem, because when you meet someone, you're going to have to duck into someone's driveway. That's just the long and the short of it. I live on a county road. Doesn't meet county standards, and we have to do that.
Yeah.
I mean, it's impossible in some places to pass, and so you have to get along, and that's okay until a neighbor raises Cain about someone pulling into his driveway because it's private property, which happened. So I guess, again, I have no issue with the family conveyance. It is a bit of a concern with regard to the roadways. I mean, as long as everybody gets along, I mean, it'll be great. But down the line, when perhaps this is not owned by a family member, they may not get along as well. I mean, I don't know about that. I mean, I can't look into the future. But again, I really would, and I don't know how to do it, Chris, I mean, about the consistency with these. I mean, I don't know if you take a look at the last one that was signed and try to make it at least close, But yeah, when I got them today, I'm reading them, it's like, holy smoke. I mean, I've seen much worse with regard to those agreements, and they're not enforceable until someone wants to get a loan.
And there was a time when the county did not have the form agreement where things were actually worse, I think, where it required there be one on record, but then everybody just drafted their own. These at least have some of the same provisions. And so that was, I think, one of the balances that the county struck when they created those maybe a decade ago.
Yeah, the tripwire is loans for the banks. Right. They want to make sure that it's maintained. Okay, that's fair. Thank you.
Mr. Buckman, what's the width of the blacktop part of the driveway that's on there now?
About 11 feet.
Okay. And what's the county standard for a road like that? If you don't know, I can ask Donnie Mills.
County standard, I believe, is 18 feet.
Okay. I know the O'Grady's property is their part, of course, their driveway is, I don't know if it's millings or crushed blacktop or whatever, but theirs is a lot wider than that is.
I don't think it's a whole lot wider, no, sir. It's
think it's-
gravel and milling, so it's a little more variable than the asphalt.
It's
portion.
wider. You can just say it's wider, can't you?
Yes, sir, it's wider.
It's wider, yeah. Well, I know because they have a thing goes around the barn, I just rode to the back of the road. I didn't go, I can't talk to anybody, but I guess I did the same thing as Mr. Evans did. I just wanted to check that out. After it leaves the blacktop, it's actually better for anybody that lives, I'll say, on the back part, especially if you have any sort of trailers or anything. I noticed that it was said that farmers go back in there at times to do various fields with various equipment. I don't know how they come down that blacktop driveway with a combine or anything like that, or a large tractor with any sort of tilling devices on the rear of it. Must be fun. It's a very narrow driveway at the beginning. Okay, that's all I got. Anybody else have any questions? Okay, we're going to open it up to public testimony. I have one person that wants to speak off the sheet, but I think what I'll do first is let anybody call in. We'll get the call-ins done, and then we'll hit the lot. Well, I guess since the people are here, I'm gonna let the people that are here go first. The only person I have on my list, and if there's anybody else, you can stand up after, but I have Sean O'Grady. Come up to the microphone. You can use the desk or you can use the hand one, whichever one you're more comfortable with. And I did get to swear you in.
Yes, sir. Bear with me because I'm not a public speaker.
What you got to do is give me your name, your address, and tell me
Okay.
what you want to tell us.
From listening to you guys, I assume you read most of my letter.
Give me
So,
your name and address first.
good evening. My name is Sean O'Grady, and it's my understanding you received my letter. I would like to read through it and answer any questions you may have for me. My wife and I live at 23890 Brick House Farm Lane. Our property is identified as Farmstead B2, and the gravel portion of Brick House Farm Lane runs through our property. The proposed lot, Lot 1A, will access the gravel portion of the right-of-way through our property. We've recently observed a PC public notice sign posted on Brick House Farm Lane and looked into the details of the request to add another family lot to the existing right-of-way. As a user of Brick House Farm Lane, we have concerns about adding an additional lot and traffic to the right-of-way without making upgrades to the road. We have no ill will against the Owens family. They're good neighbors. We understand their desire to create a lot for their daughter. However, we have real safety concerns about the existing road, and if another lot is added, and would ask the PC to consider the following during their deliberations. The proposed lot will be provided gravel access through our property. We have solely invested at least $10K in the developing this gravel portion of the road. We understood there would be one additional lot, which the Owens family also owns past us. Believe it's 19 acres. That when we bought the place, we knew that there would be a house there if they wanted one. And we were fine with that. Adding a second dwelling, Lot 1A, we will decrease the lifespan of our right-of-way, requiring additional upkeep and increase our financial burden, which as of now, we paid from the asphalt all the way. It's been only us. Our private right-of-way that we installed is approximately 500 foot. It was inspected and approved by the county in accordance with our approved building permit site plan. It was approved as 10 foot wide, which I know, sir, you had said it's a little wider now. Well, coming in there, it was soft land when we first did it, so over time, us driving, the gravel's kind of pushed out. So I would say you're probably looking at about 12 foot and where the gravel is now. 10 foot wide with 2 grass swales, 2 18-inch road pipes, road cloth, and gravel. This private road access is not sustainable for the proposed lot. We have already invested $900 in paving and $250 in sealant towards the asphalt portion of Brickhouse Farm Lane in the last 2 years because of the heavy wear and tear. More houses and excess traffic will increase the maintenance of the road. And with the sealant, yes, it is a nice road coming in there, but once you come up to the first house and have to bear around, the sealant is pretty much a Band-Aid. It's spider-webbed, cracked all the way through there, and that's when Mr. Owens came to me this past summer and asked if we would want to give to it to, make it last as long as possible. So down the road, don't know how long that's going to last before we would have to repave that part also. When we bought the property, we were under the assumption there would only be one other house using the right-of-way. Now, on our plat, it did show that Mr. Owens' farmstead has use of that right-of-way also, but his house is off of Windy Way, so we assumed that would just be because he has part of a field on that side also, he would have access to get to his, field with farm equipment or whatever else he had. There are already 7 lots, 5 farmsteads, and several in-law apartments that use Brickhouse Farm Lane, which doesn't mean there's that many houses, but an in-law apartment, you still have more cars using the road also. Brickhouse Farm Lane does not currently meet private road standards because there are technically only 7 lots. The farmsteads and in-law apartments don't count. It is our understanding that the private road standards require the road to be 18-foot wide with 2-foot shoulders on each side, provide proper turnaround areas for vehicles, as well as address stormwater management if the additional 8th lot is approved. You guys said that there was multiple road agreements. When I bought the land in 2018, I don't recall signing anything or anything on that. So there's currently no maintenance road agreement to my knowledge. The width of the road is not wide enough to pass. Neighbors have to either pull completely off the road into the grass or pull in another driveway to get by. There is no turnaround, and mailboxes are lined on both sides of the road. The current users, however you want to count them, on this road create a lot of traffic. Everyone goes in and out every day for work and run errands, mail carriers, Amazon, FedEx, UPS, propane, oil trucks. There's a trash truck that comes and gets a dumpster. We also have Bowles Farm bring heavy equipment and trucks down Brickhouse Farm Lane to work multiple farmstead properties. We do not know how many people actually live in our neighborhood, but think about how first responders, including fire trucks and EMS, have to get down our lane in an emergency if they need to. There's no turnaround area, and in wet, sloppy weather, it could be difficult. Subdivision ordinance number S10-1, section 3014-4 provides that an additional lot for an immediate family member may be authorized under certain conditions. Condition 4D states that the property owner shall demonstrate that the private road is adequate to accommodate the additional traffic generated by the lot. Private roads created within a property being subdivided shall meet the private road standards of this ordinance. We feel as property owners on Brickhouse Farm Lane, the road is not adequate to accommodate an additional lot, Lot 1A. To add another lot, we believe the road should meet the private road standards and provide a safe and effective road for all the landowners using Brickhouse Farm Lane. We appreciate your time and consideration in this matter. Also, with the submission of our letter, we provided photos that we feel demonstrate the narrowness of the road and the roadway concerns. I don't know if you guys have the pictures or not, but I took pictures of my wife's car following her in there, tried to be as fair as I could be. She has a small SUV, I call it a crossover, whatever you'd like to call it. I think the pictures show that it'd be very hard for anybody to pass each other or, get around without going into somebody else's driveway. In certain spots, there is mailboxes on each side of the road. But that's what I have for you. And my only other thing, I was listening to what you guys were saying with the family. For a family conveyance, shouldn't should that be, and this is a question to y'all, should that be if you are landlocked or have no other way and really want to give your child a lot off your land? If Mr. Owens already owns a farmstead past me that is already approved and cleared to put a house in, and when I bought the place, I was fine with that, is that something that it doesn't matter how many lots else you have, that you can still apply for a family conveyance provision?
Mr. Hunt, do you want to answer that? I mean, I can give an answer, but you're the authority.
And it's just a question, I don't know.
I want you to get your questions answered. Yes, sir.
Good evening, Bill Hunt, Land Use and Growth Management. The ordinance doesn't say where the entrance or where the access to a lot conveyed through the family conveyance process comes from. The fact that the family owns property that is accessed off a different private road doesn't mean that this lot would have to be accessed off that other private road.
Do you understand it?
I think he's saying that I'm thinking that he should access this lot off of another road. Correct, sir?
It doesn't have to be.
There's a private road that hits a Brick House Road, Windy Lane?
Yes.
Windy Way.
Windy Way.
Yeah.
And that's where Mr. Owens has access to his house. And I thought what you were saying was, would it be a requirement of the county that the access to the other lot conveyed, or the lot we're talking about to be conveyed to the daughter, would have to have its access off of Windy Way, or Windy Way, instead of off of Brick House Lane? And the answer to that is no.
Yeah, no, sir, that's, thank you, but that's not what I was asking.
I
What I was asking is, if Mr. Owens owns 19 acres, it's approved, he can build a house tomorrow if he would like. That is,
I understand what you're asking.
that is past me. And when I bought it, I understood that. I was fine with that. To my house and another home, I understand. You know, I was fine with that when I bought it. Should he be able to, or anyone should be able to go through this Family Conveyance Act if you have a lot right next to it that's already approved?
Well, the ordinance doesn't say just because he owns a lot that's already created vacant, he can't go through this.
Okay.
It's his right.
It's his right, yeah.
He can ask to go through this.
Okay. And I understand, and I guess I think, okay, we already have 7 lots, we're full. We're going to go through all this to get another lot, maybe have to upgrade the road, this or that, when we have a free lot, not a free lot, but, you know, a lot next to it that we wouldn't have to do any of this for. But again, that's, you know, just a question, just a question.
I understand.
So, if you have anything for me?
Let me ask Randy a question.
Yes, sir.
From that. Is Mr. Owens' farmstead included in the total you gave us in the beginning? You know, where you said
Yes, yes.
So that's already included?
Absolutely.
Okay. And because it's a farmstead, they can still have a family conveyance for another.
Sure. So it can ask to have another lot created because it has the density to. The reason it has to ask for a family conveyance is because they have too many lots under 15 acres on these private roads.
Now, isn't that lot being conveyed like 21 acres?
No, the lot being conveyed,
Oh, I thought it said somewhere on the,
the proposed lots, I believe, only like 6 acres.
okay. Something
But
I
it's
see
being
said-
created from an existing farmstead that's 20 acres,
Gotcha,
20
gotcha.
plus acres.
Okay. Okay.
And then the farmstead Mr. O'Grady's talking about is next to it, and it's 19 acres.
I see it on here. I was just wondering if that was already included in what you had given us
It is.
earlier. Okay.
It absolutely is.
Mr. Chairman, I have a question.
Go ahead.
Mr. Brady, how many homes are past your house right now that are currently using that road?
As of now, no one. Now, there's a 19-acre farmstead that the owners also own that, as long as
It's a
county.
potential.
Yes, they could have a house there. So on my gravel, it's me, and there would be this home, and then if this Lot 1A got approved, then there would be 3 homes that use this essentially gravel driveway.
Thank you.
Yes, ma'am.
And Brandy, how many acres did you say Mr. Owens was asking for in this family conveyance?
I believe it's 6. Let me pull this. I'm sorry, bear with me. I want to tell you the exact number.
Or if Mr. Vuckmer has that information? You-
57,
Sorry,
but there's a whole
thank
bunch
you.
of families that got to enter.
Okay, and that's at 4.99 acres, and how big is the lot itself?
21, right?
So he could still have the farmette and the family conveyance?
So they could have.
There'll be a density reservation on the larger farmstead
And what is that?
to support the lot that's being created. Because it needs 10 acres. 10 acres or 2 development rights.
Mr. Evans?
Yeah, Mr. O'Grady, in your comments here, you mentioned it too. You say you invested $900 in paving and $250 in sealant
Yes,
for the
sir.
road. Was that something that Mr. Owens asked you to do or ask everyone to do?
Ask everyone to do.
And so, of the pavement, there were, I guess there were 5 asks. That's $4,500?
I believe it was 10,000, sir, for the, and Mr. Owens maybe could tell you better, because he kind of,
What I'm getting to, we're back to road maintenance agreements again.
yes, sir.
And trying to be as fair as we can with regard to maintaining the roadway. And it is difficult sometimes to get people to sign road maintenance agreements, especially ones
Yeah.
that are after the fact,
Yeah,
since
Yeah.
they didn't sign one. And there's a question as to whether or not they're required to maintain the road.
yeah,
Fairness says that they should.
yes,
They should do
sir.
the right thing.
And my thing is, okay, I've put, I believe the asphalt portion, just the straight part, if you
Right,
went in
right.
there
Yeah, I
before
saw
it
that.
goes, that was repaved.
Was it? Okay.
And everybody gave $900 apiece, and I believe it was around $10,000.
Okay, so the pavement that's there now was a repavement, is what that was?
Yes, the straightaway. Now,
Okay.
once you get around that turn where I said it was cracked up in spiderweb till you get to my millings. Now, going Windy Way, I don't go over there, so I'm not sure, but that is what the back people put into that for $250 a piece. I believe it was $250 or $300. And now the millings and the gravel all the way through, so I use that and I'm fine with that. I'm using all that, and when I gave the $900, I hadn't even moved into my house yet.
Okay.
So, and I was fine with that. Now, to me, so then everybody should have pitched in or should maintain my gravel then? Is that, if that's part of the road, that
In a perfect world, yes.
is,
Welcome
that's
to
my
an
thing.
imperfect world.
Yeah, exactly. And truthfully, with just me, I have horses and a little horse trailer and go.
Right.
I'm all the time already fixing a pothole and whatever else, dragging it, bringing the gravel back to the middle, and it's just me and my wife.
Yeah.
So,
Yeah, enforcing these things is difficult to begin with. It really has to be
Yeah.
sort of a moral decision to do the right thing.
Yeah.
Everybody work together, everybody keep the
Yep.
road up. Don't drive fast, don't create
Yeah.
potholes, don't, do all those kinds of
Yep.
things. And so anyway, no, I was just curious about the money that you paid.
Yes, sir.
And trying to figure out whether others had paid, and in reality, they have.
yes,
They
for
did.
the
They all
asphalt
made a
portion.
contribution.
Yes, sir.
Okay, great, thank you.
Mr. Murphy, can I ask you a question?
Hello.
Hello. You've heard all the last little bit of this and talking about the front road maintenance agreement for the, I'll say, the blacktop part of the driveway versus, his end of the world. What's your opinion on that? Should I'll say, the landowners that live on the blacktop be putting in a fair share to help this gentleman out with his end of the world? Or
Must they?
just asking your opinion on it, Mr. Murphy.
Yes, I mean, it is only fair. If you're using that part of the driveway, you should pay. If he's having to pay, well, it's tough because he's at the, I understand it, he's at the end right now.
He'll be next to the end if this goes through.
Next to the end. And he's obviously paying for that which precedes him because he's driving over it, as are those who are afterwards. Should the people in the front have to pay for the part that they don't use in the back? It's sort of a reverse of the same question. Is it fair to pay for something that you don't use? These are all should questions. I mean, they all live on the same street. It's to their betterment to have everything work and not have potholes. I mean, should they? Probably. Must they? If they agree to it. Yeah. It depends on what each road maintenance agreement says. I heard I think it was Mr. Vuckmer stated, maybe it was Mr. Longmore, I don't remember, stated that with each new road maintenance agreement, it'll be like 1/13 or however much. So if they all agree to maintain the entire length of the private road, each paying their fair share, I mean, that maybe it's the fairest distribution, but not necessarily equating to the actual use of that road, since the person in the front would just drive up and then pull into their driveway in most circumstances, rather than driving to the end that they may not use, and should they pay for it? I don't know. Long-winded question. Should they pay for it? I don't know. If they agree to it, yes.
Yeah, but that's not where we are.
Yeah. Well, let me ask you a hypothetical question there, Mr. Murphy. I have a farm road. I've got eight members that live down that. Half of it's blacktop, half of it's millings, 4 in the back, 4 in the front. I'm getting ready to come up with a road maintenance agreement. If it was I'll say a legal road maintenance agreement, it would be 8 people are paying for whatever maintenance it takes on that road. Unless, I guess, the lawyers for the applicants or the homeowners come up with and say, well, and then it would have to be signed by all 8 people. Otherwise, if they said, well, us in the front shouldn't have to pay for the back, so we're going to split the half of it up for that, and say the neighbors agree with it, and then sign it. And let's say the neighbors don't agree with it, and doesn't get signed, but there's not anything they can do about it, though, is it? What was that?
Oh, I just said, right. I was just
Okay.
agreeing that it's a tricky question. No,
Okay.
it's tough because it requires people to have some sort of moral floor.
Well, sometime in a perfect world, the county's going to have to come up with a good way to do road maintenance agreements.
Right,
Because,
no, certainly.
I mean, it's, what's fair is fair.
Yeah,
Mr. Chairman,
Yes, sir.
I got another hypothetical for you. All right, let's say everything was approved, you got your 8 lots. Comes time for road maintenance again. This blacktop, does he get to share in the new blacktop, but he's paying for the blacktop all the way to his house, or his percentage? So now, does it get blacktop from his house to the one past him as well? I mean, what's fair for the goose is fair for the gander.
Right.
It all depends on what they, in a contract,
Just to maintain the road.
right, just to maintain. It really depends, I guess, as they say, the devil is in the details. It depends on what they agree as to how it should be split and what type of surface they'll use.
and from where it starts to when it ends. Everybody should, in my view, everybody should pay for it since everybody's probably using it.
The blacktop comes all the
My
way
parents live in a
from
similar
there,
situation.
right down to right
They're
here.
at the front, but they still pay for the people in the back because it's everybody's sort of use. They see that that's the right thing to do, but everybody's kind of different.
Yeah, that's the
I don't know.
ladies. This is gonna be
Just
the
saying,
new-
it all depends on what's in the agreement, I guess. And what all the property owners agree to do.
May I ask a question?
Yes, ma'am.
So the only reason that this road would not be held up to public road standard with 8 lots is because it's a family conveyance, correct?
In this particular situation, that's correct.
So what would the difference be between the public road standard and the private road standard?
Quite a lot. So
Ouch.
it's
$250,000.
in 30.14, which is all the private road standards. So there would have to be, public road, many standards that are not just for private roads, but private road standards. I think there has to be, this comes up a lot. So it would be, I think, turnouts every 1,000 feet. I actually have, fortunately, so there are a number of things. The standards are in 30.14.5, so I'm glad I anticipated the question. And it lists a lot of them, so they have to be designed to allow a 30-foot emergency vehicle to come through. They have to have,
And this is private or public?
this is a
Excuse me.
private road. So
Okay.
public road would be admitted into the county road system. And then there are even more things beyond what I'm describing here.
Okay.
But there are A through J, however many numbers that is, 4, 8, I don't know,
Okay.
10 or
10.
something standards.
Big difference, but
Right.
the reason that this is able to get past that is because it's a family conveyance.
You're
as
exactly right. Yeah,
Mr.
so,
Longmore had said earlier.
and exactly, so the type of cost that would be associated with a road maintenance agreement for something that doesn't have to go to private road standards would be significantly lower than something that has to have like the width that's required and the turnouts and all those things.
Thank
That
you.
would otherwise be required. Oh, sure, my pleasure.
Any other questions?
I remember you saying that you said you hadn't signed one.
Sir, not to my knowledge. When I bought it, I'm not, settlement, I'm excited, I'm buying this place, During my settlement in 18, me and my wife, we've looked through everything I have. I don't recall signing anything or have anything in my record saying that. Now, if somebody else does, and then I'm sorry, I'm wrong. But as of now, I don't. And it's, to me, a road maintenance agreement, okay, I don't care about keeping up on the gravel. I don't want any money from nobody. I'll take care of it. It's the fact that keeping up on the gravel and keeping the road nice is great, but that's still not addressing any of our safety issues on making the road any wider than what it is. If we're still at 10 foot or 11 foot wide, they said, in private road standards, they're saying 18 foot wide, we almost are double, we're less than half as wide as we should be. That is more my issue than the road maintenance agreement. I think all my neighbors are great and they all would pitch in and that wouldn't be the problem on keeping it up. But it's still the fact of the safety and turnarounds, EMS, more people in and out. You got to back up, get in somebody's driveway, let somebody else pass you. All those things I feel that should be addressed or brought to those standards before we add another lot.
I think if that being the case, then you would have been responsible, along with the other people on there, to come up with a much wider road, which would cost you a lot of money, cost them all a lot of money. Though this road has been used and it has met a standard where there hasn't been any problem that I've heard of tonight, wise that said, said fire truck couldn't get down there.
Yes,
Lord
sir.
knows if Tommy Bowles can get down there with a combine and towing whatever he's towing behind it without tearing up, I'll say, either side of that road, it must be somewhatly safe to come down.
Yes, sir.
Now, as far as the backing up, I mean, that's kind of living in the country
Yeah.
type of world.
And if, I don't want to talk out of line, but if I was wanting this for myself, then to me, I would assume that responsibility. Why should my neighbor, if they don't want to, if they're not doing the other lot at their house, why should, I wouldn't expect my neighbor to pay for me to have to widen the road if I want my child to live there.
Being in your case, I don't know if you could, because you've got, what, 15 acres?
No, sir, I don't, I would have to check, but
Yeah. Do you have 15
Yes,
acres
sir.
though? I mean, I think you have to have a farmette, and then you'd have to cut an additional lot, and that would take you out of the, let's say, farmette end of the world.
yes, sir. Yeah, that's just a hypothetical thing. If I did have 20 acres there, you know, if I wanted to do that, then I wouldn't assume that my neighbor should have to pay for me to widen the road.
But I really think that some of these ordinances, like the family conveyance, was put in because I think I heard Mr. Buckmer say that it was like 1,300 feet of paved and 700 feet of gravel. You know, so you're close to a half a mile. If the end person, you being the end right now, had to bring that up to county standards, I mean, I don't think you know what you'd even be, I mean, in hundreds of thousands of dollars to prepare that for blacktop and cutouts and stuff. So I think that's why the family conveyance was probably put in there, because I think whoever did it, I wasn't on the deciding boards or committees, but probably figuring that if their parents are in there, or their child, a mother, father, daughter, son is who the family conveyance is for, is going to visit anyway. Some, I'm not saying as much as somebody would come in and out, so. But it would be, not saying it's right or wrong, just saying that it would be an astronomical expense that most single homeowners couldn't or wouldn't be able to do. And unfortunately, I've dealt with a lot of road maintenance agreements. They're not worth the paper they're written on, for the majority of them. You guys are good neighbors, and maybe the other neighbors you said all pitched in when Mr. Owens asked for money. That's great. You know, we have 7 on our private road, and I think when we decided to pave it, and it's 1,000, 1,200 feet, we only expected the people at the beginning to pay for the first 100 feet, you know, because
That's all.
I mean, if I was in the beginning, I'm not going to pay for something 1,200 feet back.
Yeah.
It just it wouldn't make common sense to me. But nobody paid except 1 or 2 people. And your only option, like I think Mr. Longmore said, is litigation out of your pocket. You know, you got to hire an attorney. They got to do all, you know, multitude of hours of work to see what's recorded, what's written, and then you go to court and, you know, I mean, not an attorney or a judge, but it's not favorable for most people. So if you can keep it like you guys sound like you do down there, keep it as well as you can in the front with everybody pitching in. That's a really a rare thing on a private road where you can get people to. And I think why it's not enforceable is, I mean, you may be fine having a gravel road, but what if 7 of the 8 people want a fancy blacktop road, and then you're propelled to pitch in $10,000, you know, that somebody may not have. So it's a hard thing to do that, but just giving my 2 cents on why I think some of these provisions are there.
Okay. Thank you.
Yes, sir. Thank you.
Mr. Chairman?
Yes, sir.
I have a question for, I guess, for either Mr. Hunt or Brandy. When people go to get in-law attachments to their house, that
Right.
requires a permit?
It does.
So actually, we do have a number as to, let's say right now, let's say there was only 8 lots on that road. But actually, it's more than that because do we have a number as to how many?
I don't know the number on this road, but we don't count users or dwellings. We count lots when it comes to private roads. So it doesn't matter how many, you could have 20-acre farmstead, and you could have, if you have the density for 3 houses, put those 3 houses on there. It's not going to matter to us until you subdivide. Then we're counting it.
Right.
And it's going to count toward the private road. We don't care if you have an accessory apartment. It's not going to count toward the private road. So we could get you a number, but I don't know what it is off the top of my head.
I agree to disagree. If each house on there had an in-law apartment, now you're at 16.
Oh, I agree with you. They're adding trips
I mean,
to the road.
this is basically what he's talking about, is that now you can have an in-law on a place on there. And originally, say when I bought it, my understanding was there'd be 8 families using the road. Now you got in-laws coming in, that's additional 2, or maybe a single
Sure.
mom or dad.
Sure.
I feel his pain.
No, I understand what you're saying, but the subdivision ordinance doesn't tell us to count users. It tells us to count lots.
Right.
Brandon, so quick question, then I'll, just curious now that you said that. So the farmstead that Mr. Owens owns is 21 and some acres. So his daughter could build a house on that using 10 acres of density and not even count as another lot,
Correct.
if they wanted to,
She
without
certainly
even
could.
having to go through a family
Right,
conveyance.
absolutely.
Or since you only count lots.
Absolutely.
Okay.
Correct.
She would just need a permit.
Okay.
Any other questions?
One more. Is it my understanding that the current road does not meet the standards for a private road?
That's true. It does not meet the private road standards. And as far as I understand, they're not asking to upgrade it to private road standards either. It does not meet the private road standards, and I don't believe they're asking to upgrade it to private road standards. They're asking for the family conveyance provision. They're asking for the exemption. So when you're adding lots to a private road, lots under 15 acres, to a private road that existed prior to May 13th, 2002, it's exempt. It's exempt from private road standards. So that's likely why it doesn't meet private road standards.
But
Much we can do about that.
now, with that being said, it's exempt until you want to put an 8th lot.
No, it's not. It's not exempt. First of all, they can't do that at all unless they get the family conveyance provision granted.
So what is this 7, why are we, you think 7 lots, okay, we got 7 lots, now we're full,
The ordinance limits you to that, the subdivision ordinance.
so then you can put this 8th lot and it doesn't,
If you get approval, you have to go through this public hearing to ask for approval.
okay.
That's what we're doing now. You
But the
can't
only
just,
way is a family conveyance, right? If there
Correct.
was another lot.
otherwise you have to upgrade the road.
If there was an 8th lot that wasn't a family conveyance and somebody's asking to use that, then the road has to be brought up to
County road standards. Right.
Right.
That's the hook, that family
That
conveyance.
got straightened out, yeah. Took the barb off of it. Okay. Any other questions, Mr. Owens? Mr. O'Grady, sorry. You did well. We
Thank you, sir.
hammered you with everything we could give you, so.
Yeah, this is my first time, I'm like, I hope it's my last.
Well, for this,
Me and my wife would like to thank all of y'all for listening to us, and any questions you answered, I appreciate it.
Thank you.
Thank you.
Thank you.
thank you, sir. Okay, Randy, you want to see if anybody's called in? Is anybody else in the room going to speak? Want to have you? Okay, you want to see if anybody's called in?
Planning Commission public hearing.
Hi, Kimberly. Do we have any callers?
No, we don't.
Thank you.
You're welcome.
Okay, we'll go ahead and close public testimony. Mr. Longmore, you want to give us any rebuttal?
Thank you, Mr. Chairman. Just a few comments to make in response to Mr. O'Grady's testimony. And we certainly appreciate the tone. My client appreciates they are good neighbors. And it's nice when people have concerns and they don't have to yell at each other. I know we see it in this room the other way, so it's nice to see that tonight. A couple of things just to mention. This road actually serves 12 different properties. There's 5 farmsteads, I believe, and 7 lots under 15 acres or under the threshold. The O'Grady's actually own one of the farmsteads, so if it were not a farmstead, that would not allowed to be there. So that farmsteads also have the exemption. You know, you're allowed to be over 7 lots if there's an exemption. And one of the things that I always think is important, I know it's important to this commission, is kind of be fair to everybody in there. And with that farmstead not being allowed there, absent of being a farmstead, we believe this is a similar exemption that the commission should consider. And certainly the road maintenance agreements have been discussed a lot tonight. There is a road maintenance agreement that is one of the ones that is on board docs that relates to the O'Grady's property. I'm not surprised. It's not something you need to sign when you buy it. It's something that's already in your title that a lot of people don't even know is there when you buy a house, but it gets recorded against your property. So that's actually a covenant on his property that is on there. It's agreement number 5 on board docs. It's the last one that's listed. I believe the O'Grady's own Farmstead B, so I think that's where that came from. That road maintenance agreement was recorded in 2015, it looks like, or it's at least dated April 3rd, 2015, as I understood Mr. Grady. They purchased their property in 2018. One of the things that I think was apparent from Mr. O'Grady's testimony, and we want to make clear, is that this is a road where people generally work together and they're not fighting, which is great to hear. My client was listening to Mr. O'Grady and can certainly appreciate his concern of the gravel road that he's built up on his property, and now somebody else will be using that, and potentially a second one would be using that. And again, I know that there's difference between use and maintenance costs, but my client is willing and is proposing a condition on your approval tonight that if this lot, you know, if the house is built here for his daughter, once she starts using it, once they get a building permit, they will agree to pay 50% of all upkeep, and even during the building process, because they'll be using it then. So I guess at the issuance of a building permit, they'll be agreeable to maintain 50% of the road that exists on the O'Grady property that he's put money into. They'll be the only 2 using it, so it's fair to split it 50-50. Really, Mr. Owen's daughter will be using probably a little bit more of it because she'll be driving to the end of it, but they're willing to split it 50-50 in fairness. He's also willing to make it a condition of the approval that the farmstead that they own, should that ever be developed with a house, would pay an equal share as well. So then it would be 1/3, 1/3, 1/3. At that point, it would mean the O'Grady's would only be responsible for 1/3 of the cost, and the other 2 properties would each be responsible for that. That's how these road maintenance agreements work, and they're fair, is when you look at who's using it and you divide it equally. There's still other obligations of everybody for the rest of the road, but they're willing to make that specifically as to the O'Grady property, since that's a concern that he's raised tonight, which we'd ask that you consider as being fair. I asked Mr. Owens how it works now, and he's told me that as to the asphalt, everybody chips in because everybody uses it, so they chip in equally. Once it splits off in the 2 different directions right now, the people in each direction pay the additional share of that. This would be in line of the practice of the neighborhood as well. So we'd ask that you consider that. You know, and certainly we know that it's a concern when somebody else is using the property, when you add other users. You know, again, we'd ask that you consider this is only 1 lot that's being added. It's for his daughter. And there is a policy that is in place here that the county commissioners, when they adopted this, thought was important enough to make an exemption, to the private road standards if somebody wants to leave a lot for their child, if they own property there. As I know this commission knows, in the early 2000s, that's when development was really starting to kick in here, and it was a balance of those who already had family farms and land and had lived there a long time, wanting to be able to provide for their families, but also putting restrictions in that were good for the county as a whole. This is the balance that they struck. I believe in the staff report it mentioned, I think the Owens have owned their property since 1995, if I understood correctly, so over, for a considerable amount of time, over 20 years. So to be able to make a lot for their daughter, we think is a reasonable request, and hopefully that proposal to condition it upon them also assisting Mr. Grady, who certainly might not have seen this coming, but the rules have allowed for this since before he purchased the property. By them sharing that cost and agreeing to do an opening tonight, we'd ask you to consider that and approve the request.
Okay. Thank you, Mr. Longmore. Okay, all testimonies closed, and I'll open it up to the board for deliberation.
The only question I have is that Mr. O'Grady,
Grady.
understand what Mr. Longmore just said.
I understand that he wants to,
Okay.
the Owenses would go 50/50 for that and all.
Oh, you want to come up to the microphone, please? Thank you.
I understand that they would agree to do 50/50 for that and for the road maintenance, although, I guess through this conveyance, they can do this. It's not, to me, it's not making the road any better, but I appreciate them doing 50/50.
Okay. Thank you, sir.
I think they'd actually do 50/50 for the daughter, and then if Mr. Owens decides to build back there, it'd be 33 1/3, I think is what Mr. Owens
Yeah.
said.
Yeah.
So you'd be paying a third.
Yep.
Mr. Owens and his daughter would each pay a third, so.
Yes, sir.
Just so okay.
Yeah. So that would be, and we would probably need more upkeep because three homes on that little gravel lane would definitely need the upkeep.
Okay. All right, well, he's agreed if it does pass that they will do that, so.
I appreciate it.
Thank you, Mr. O'Grady. We just want to make sure you understood that. Okay.
Good. Thank you.
Thank you.
Anything else from the board? Anybody
Just thank Mr. Longmore for bringing that forward.
else? Yeah. And the applicant, Mr. Owens? Thank you.
I'm sorry.
Well, if there's no other deliberations, would anybody like to make a motion? Calm down, everybody. Now. Make a motion.
Go ahead.
I can. Let me get to that point.
I'll let you off the hook. You're the vice president.
Unless there's any other deliberations. I mean, nobody
I
is.
just have one question. How do we get that in the,
Condition it.
that condition,
The
sorry.
condition.
In the
Just add it to the motion.
motion? Yeah.
If it's approved, if it's a motion for approval, then it would be with the condition of,
Yeah, that's what I want to
Yeah.
make sure before
you want to make a
we
motion?
begin. No.
Okay.
Let me ask one question before the motion. What is the lot or parcel on each one of those two, Mr. Owens and the one he wants to convey? Is there something that I can reference in a condition?
Oh,
Is,
Yeah.
there is definitely, but let me tell you exactly what it is.
Thank you.
So just bear with me.
That way the lot's
So it's spelled out.
Oh, I know, yep.
I can give you an address. The address on Mr. Owens' lot that he's getting ready to partially convey is 23850 Brickhouse Farm Lane.
And then you want to know, and Mr. O'Grady's,
Mr. O'Grady's is
No, not
23.
Mr. O'Grady's.
you don't want to know his?
Want to know the one Mr. Owens has
That's
and the
tw-
one that's being subdivided. Is that
Well, the
subdivided
one
yet?
that Mr.,
That's one and the same.
the one that Mr. Owens has, the 21 acres is being subdivided. Now,
It's not done yet.
Yeah,
correct.
Gotcha.
that's
Now, there's
23850.
one next to it that will share in the third, if it's approved, that Mr. Owens owns as well. Do you want to know what that's called? That's the 19.
Actually, that hadn't been well, I'm just going by the county tax map. That hasn't been subdivided yet, so
Well,
it's all
it
still
has.
one
You
engine.
can't go by that, because that's
Oh,
not,
well,
that's
then
not
you better
accurate.
tighten this up.
See where it is.
So let me tell you, so Lot 1 would be the third lot that would access the portion of Brick House Farm Lane coming from Mr. O'Grady's property.
Let me see it on here. Can you bring it up
Oh,
where
can
you're
you
going?
not see that?
Yeah,
Why isn't that being shown?
It
Can you
is.
see it up here?
it's the
So
one that says
you have to remember that
23850
this
Brick House
map
Farm Lane.
is inaccurate.
It's
So this
cyber attack.
would be the third lot once it's built, accessing Brick House Farm
How do you see that?
from here. See?
So then it's
So this property
23815.
here, this Farmstead 5000-1, that's what's being subdivided, proposing to be subdivided now. So Mr. Owens owns two lots.
So he's not subdividing 23,850 right now.
Correct, he is not. That blue dot is just ignore that. Okay, so he's subdividing 43,525 Windy Way,
That's his house.
correct?
Okay, so he's subdividing that, and then he still owns the,
And then he owns 23,850, yes, which also has access right now through Mr. O'Grady's property off of Brick House Farm. That's its platted access.
the only way he can subdivide that is keep it as a farmstead, right?
Right, yeah. Well, I don't know if he has more children that he could give
So
a
the family conveyance
to.
doesn't limit to the number of, it's just, you can go 9, 10, 11, 12 lots under 15 acres
Correct,
if it's
right.
family
So
conveyance.
each child can only get one family conveyance. But,
Right.
right, if he has another child, he could potentially do that. But he'd be back here asking,
No, I understand.
or upgrading to a county road standards.
So how can we word this?
I didn't hear any answer in that.
So it's lot 5001.
Correct.
Okay.
In Lot 1, if you want to add that in.
No, I don't think that's part of this right now.
Okay.
What he's going to convey is a 4.99 acre parcel.
Yep, that's the proposed lot.
Okay. I'll try it.
Good man.
In the matter of minor subdivision number MSUB, Brick House Farm subdivision, having accepted the staff report and having made findings pursuant to section 30-14-14 of the subdivision ordinance criteria for approval of a family conveyance, I move that the family conveyance subdivision plan be approved with the following, with the conditions that agreements ensuring access to, use and maintenance of the road shall be recorded with the following condition. Lot 5001 is being subdivided into a 4.99 acre parcel for a family member, which agrees to pay 50% of the road maintenance agreement until a time that Mr. Owens chooses to build in the rear. Then it would be a 33 1/3 between the O'Grady's, Mr. Owens, and Mr. Owens' daughter, April Owens. I mean, it sounds kind of confusing, but
You could just say Lot 1, because that, Lot 1 is actually different
Right. You just say,
than what's being subdivided
okay,
right now.
I'll take that amendment.
Because he could sell that to anybody.
True. Okay. So with his subdivision, let me change the condition then, since it hadn't been seconded or anything. first condition will be Lot 5001 is being subdivided with a 4.99 acre parcel to April Renee Owens, who in turn would pay 50% of the road maintenance cost until a time that Lot 1 would be built upon by Mr. Owens, or would be used. Then it would be a 33 1/3 from the O'Grady's, April Owens, and Mr. Owens, or current owner of Lot 1. Got all that? Okay. Very confusing.
It's on tape, they got it.
Mr. Longmore.
Just a point, what we had offered, and I think this is what you mean, Mr. Van Kirk, is that they'll pay that share of the road that exists on the O'Grady property, in addition to any obligations they have to the remainder of the road for the other users on it. So
It's not the blacktop.
Right, so it's the road on the O'Grady property that they'll do 50% or 1/3.
Yes.
1/3. So just
We will add that to the,
the intent.
I will add that to the written part of the motion.
Okay, I have a motion. Do I have a second?
Second.
Any discussion? Okay, Mr. Hall?
Aye.
Mr. Van Kirk?
Aye.
Ms. Summers?
Aye.
Mr. Evans?
Aye.
Mr. St. Clair?
Aye.
Ms. Roebuck?
Aye.
I also vote aye. Mr. Owens, you got some very understanding neighbors. Make sure they stay happy neighbors, okay? Same thing with y'all. Y'all got some good neighbors. Hopefully, everything will work out. Y'all got a pretty spot back in there. Keep Hollywood safe. Okay. All right, we're done with this. We're going to take a 5-minute recess, and we'll come back for the second hearing.
Glad you read my mind.
Thing at the fair.
A lot of signs out
Yeah.
there, come through here with
Mailboxes.
knocked down.
Yeah.
Okay. All right, let's bring the meeting into order. Our second, let me get to this. Second hearing this evening is number 13-120-004 for the Woods at Myrtle Point, Section 3 for a major subdivision. Okay. Courtney, you want to go ahead? Oh, I'll swear everybody in before we get started. Anybody that'll be making statements here this evening for this one, you'd stand at this time. Mr. Rathles, you going to, there we go. Okay, raise your right hand. Do you declare and affirm under the penalty of perjury that testimony and responses, statements you may give will be the whole truth and nothing but the truth?
I do.
Okay, thank you. Thank you. Going to.
Okay.
Okay, before we did get started, and thank you, Mr. Evans, our new Director of Department of Public Works and Transportation is with us also this evening. Mr. Jim Gotch would like to welcome you aboard, sir. We'll be riddling you with questions, too. Good thing you have your man, Mr. Mills, here with us also.
Don't clap for that?
Okay, Courtney, go ahead.
Okay. Good evening, Chair, Vice Chair, and Planning Commission members. Agenda item 2 is a major subdivision plan 13-120-004 for the Woods at Myrtle Point, Section 3. The major subdivision seeks approval for a major subdivision consisting of 132 townhome lots and open space. The site is located at Patuxent Boulevard in California. The land use is residential low density, and the zoning is residential low density district with an AE4 overlay. Per the St. Mary's County Subdivision Ordinance 10.3, land shall be suitable for the purpose for which it is subdivided, and adequate and effective public facilities shall be available as determined by the Planning Commission. In addition, the public improvements shall conform to and be compatible with all other county laws, regulations, plans, programs, and standards. And per 20.1.2, decision-making responsibilities as illustrated in Figure 20.1, page 20-1, the Planning Commission is the final decision maker for both the major subdivision and adequate public facilities. The purposes of residential low-density district are intended to provide for low to medium-density residential development in areas designated in the comprehensive plan. Compatible institutional uses are allowed subject to appropriate standards, and per Schedules 32.1 and 32.2, allow a density of 5 units per acre using TDRs. The required TDRs that must be landed for the major subdivision is 80. Per the comprehensive plan for development districts, they are primary growth centers located in Lexington Park and Leonardtown. They are to be urban in pattern and form and are designated for intensive residential, commercial, and industrial development supported by provision of community facilities and services. The public notice for the Planning Commission public hearing was published in the Southern Maryland News on February 11th and February 18th, 2022. The property has been posted in accordance with the CZO requirement, Section 21.3.3. Certified mail receipts have been received and have been entered into the record of this public hearing as Exhibit 1, and the agenda was posted on the website on February 22nd. The concept site plan was reviewed at the TEC meeting that was held on November 14th, 2013. Per Section 70.6.2, Planning Commission determination on major subdivisions. In the case of major subdivisions, the Planning Commission shall make the adequate public facilities determination. In making that determination, the Commission shall receive and review the Planning Director's report prepared for the major subdivision pursuant to the same standards in Section 70.6.1 for adequate public facilities study and other information submitted by the applicant. Upon its review of this information, the commission shall determine if the required level of infrastructure exists or will exist to meet the standards of this chapter and whether the approval of the proposed development will be in the public interest. At the time of the staff report was being prepared, staff did not have all of the documents necessary to prepare the planning director's report. Therefore, the planning director's report is not available at this time. The planning director's report consists of 5 categories, which include roads, water and sewer, fire suppression, water supply, storm drainage, and school impacts. We did not have the APF form approved by DPW&T at that time to complete the planning director's report. This form is needed for the roads portion of the planning director's report, and the 2007 traffic mitigation plan was in the staff report. The following items are needed to prepare the planning director's report and are available and were attached to the staff report. DPW&T approval and Soil Conservation District approval for storm drainage, State Highway Administration approval to assist with the roads portion of the report, METCOM approval, and Health Department approval for water and sewer, METCOM approval for fire suppression water supply, and Board of Education comments for school impacts. This is a public hearing which enables all who wish to provide information to the Planning Commission to do so. In order to approve the preliminary plan, the Planning Commission shall make the findings that the proposed plan is 1, the proposed development including lot sizes, density, access, and circulation is consistent with the comprehensive plan and applicable zoning standards and is compatible with the existing and/or permissible future use of adjacent property and may be served by adequate public facilities as required by Section 70.2.2, that there are sufficient number of access points for ingress and egress are provided. Generally, 2 access points are required, with no less than 1 access point for each 75 lots or fraction thereof, and reservation of land or dedication of rights-of-way to allow interconnection of subdivision streets to adjacent parcels, subdivisions, and for connection to planned roads. Public facilities are adequate in accordance with the provisions of Chapter 70 of the St. Mary's County Comprehensive Zoning Ordinance, adequate public facilities, that there's access to adjoining land is provided for in the proposed plan and will allow development of those adjoining lands in accordance with this ordinance, that the street system adequately shall be based on the street system's ability to safely accommodate trips from existing and planned land uses on the existing and proposed street system. The drainage, erosion control, and construction proposed comply with the accepted engineering and construction practices and the requirements of this ordinance. That the lot, block, and street layout are consistent with the subdivision design standards of this and the comprehensive zoning ordinance. And that there are adequate developed recreational and other community amenities are provided in accordance with the comprehensive plan, comprehensive zoning ordinance, and the subdivision ordinance. So for outstanding issues, the planning director's report for the Planning Commission to review and approve is not available at this time. And we did receive an approved APF form from DP&W&T this afternoon, around 4 o'clock this afternoon. Just to give you an update on that, you should have received an email with that information, but still wasn't enough time to prepare the planning director's report. I've started drafting it. We have to check a few other things, such as the Board of Education for school capacity. And then also the 80 TDRs are required, must be landed as part of the major site plan for Section 3, and the applicant is actively working on this requirement, and 34 TDRs have been landed thus far. So that concludes staff's report and is entered into the record of this public hearing as Exhibit 2. Representing the applicant is Mr. Longmore, and I would be happy to answer any questions you may have for me at this time.
Mr. Fanker?
I just have one quick question.
Sure.
The 80 TDRs for Section 3 were addressed here. And they were addressed in 2018, and they were addressed in 2020. They were actually a condition of the motion in 2018 and 2020, and I don't understand. Are they required for the entire project?
It's my understanding that the 80 TDRs are required for this particular Section 3.
But if you
And
look back
that
at
the-
the minutes of 8/24/20 and 9/10 of 18, both of them have 80 TDRs must be landed for Section 3.
Well, the 80 TDRs, a portion are for Section 3, but a majority are for multiple sections, say 4, 5, and 6. They got put off to Section 3. They have to be landed at this point. So that's why every time a Woods at Myrtle Point project would come before you, we would make sure that you said something like that in your motion as a condition. 80 TDRs must be landed on Section 3, so it didn't get lost.
Because they were using,
They've used all their density.
so they had, I guess what I'm saying is, they had already used any TDR or density that they had.
Right.
So only 80 TDRs was required for this whole project?
Correct.
Okay, so they had enough other than?
Oh, yeah.
Till they got to here, okay. I was just
Absolutely.
Curious, when I read back and looked at that, I was just curious to see why it was in each, as a condition of each.
We just didn't want it to get lost ever.
Well, good, because it had me thinking of, why it would note Section 3 in each one of those.
Because that's the last stop where it it needed to be landed.
Thank you very much.
Run out of room.
Exactly.
They have to land them.
Any other questions of staff? Okay. Okay, who will be speaking for the applicant?
Thank you, Mr. Chairman.
Pull this seat up.
And we have a PowerPoint that Ms. Jenkins is pulling up. Okay, and thank you again, members of the commission. Chris Longmore here on behalf of the applicant. I would also like to note, either in the audience or available by Zoom this evening, my client, the representative of my client, George Rathliff, is here to answer any questions. Barry Buckmer is here as the surveyor that prepared the preliminary subdivision plan. He'll be presenting as part of our PowerPoint presentation. We also have two individuals here by Zoom, Pat Mudd, who is one of the project engineers on the project, who is here and can answer questions you have, as well as any questions you have about the history of the project, because Mr. Mudd's been involved in it a very long time, as have I. And then we also have Mike Lenhart of Lenhart Traffic, who is here to answer any questions you have specifically about any traffic or APF concerns in relation to the traffic. Again, what we're here asking for tonight is a preliminary subdivision approval for Section 3 of the Woods at Myrtle Point. As referenced in the staff report and the questions the commission had, this project has been in development for some time. It's a project that has several sections and phases. We have some of these projects in the county, but not many that have this length to it or this type of development. It is in the development district of Lexington Park, where it is encouraged to have this type of project. And the section that we're here talking about today are 132 townhomes that are being proposed. Now, the one thing that is kind of unique, I think, about our ordinance structure, and I say that because I have clients that tell me it's very unique for us, and that when you have a townhouse development in St. Mary's County, you have 2 approvals you need at the Planning Commission instead of 1. You need a concept site plan approval. You also need subdivision approval if you want to sell those townhouses to individuals as individual units of property or individual parcels or lots. Our ordinance is different for single-family properties. They would only be here for subdivision approval for that. It's also different for condominium units, as you know. That would be just a concept site plan. So we're here the second time on this same section. The concept site plan was approved by this Planning Commission in June of 2013. So the layout, the units, the type of housing, the streets, all of that were approved as a part of the original concept site plan approval that's still in place. That was done in 2013 for the record, and so the board knows without an extension. You can tell that was done several years ago. There were extensions granted to that. It is in place. I believe Mr. Hunt can confirm that, and I have the extension letters granting that. So there is an active concept plan in place. So really what we're here tonight is to ask to be able not to build the townhomes, because they already have authority to do that, but to subdivide them and sell them to other individuals. It was brought up, I believe, when we were here for section 5 or 6, that it could still be developed without it being subdivided, but it would mean it would turn into a rental property as opposed to people being able to buy them. So that's the real difference in being able to subdivide. So both are required, and we're here kind of for the second step of the process. If we go to the next slide. This is just an overview that you've seen before at the last of our several hearings. Section 3 is in the bottom left corner to the left of the clubhouse and the pool that I know has been of interest to the community and to this Planning Commission. That was constructed and began being used this past summer. It's a great facility if you haven't been there. I've had the chance to go and look at it, and it was very nicely done. So now we're into the next phase of the project, which is this section 3 with the townhomes. If we go to the next slide. The history of this, again, the concept site plan was approved in June of 2013. It was a 7-0 vote by this Planning Commission, and there were no conditions placed on the concept site plan approval. The minutes I know are public record. I have copies if any of the Planning Commission members are interested. Since that approval, as I know this commission is aware because my client has been before you for other approvals, the owner has been proceeding with the development of other sections of the Woods and Myrtle Point, including the construction and opening of the clubhouse and pool, as I mentioned, and now they're ready to move on to this section 3. So you can see in the other sections 5 and 6, I believe, are the numbers. There are other townhouses that have either been constructed or are under construction, and this is the next step of this phase project. If we go to the next slide. These are some depictions of the townhouses. Again, you've seen these before. It's going to be a similar style to the other townhouses that are being constructed in the neighborhood to keep them consistent. We can flip through these slides. There's a couple of them. So this is another example of those. If we go to the next slide. And that's some that were actually constructed, I believe, in section 5, if I'm remembering correct, but George can correct me if he gets up and speaks. But those were ones that were under construction at our last hearing. We kept that in to give you a sense of what it actually looks like on the ground. If we go to the next slide. What I'd like to do now is turn it over to Mr. Vuckmer, who will discuss the preliminary subdivision plan that he prepared, and then we have a little bit more to go over before we'll be available for questions. And again, we have our other engineers online if there's any questions to the board from that.
So the subdivision plan couldn't be more simple. What we do is take the approved final site plan and put lot lines around the buildings. We put easements for sewer and water. We establish the open space, forest conservation areas, and the access. So the plat you see before you now has been approved by all those different agencies and is ready to proceed for preliminary approval and then record plat. Pretty straightforward. So I'm here if you have any questions about the record plat portion of it.
Anybody have any questions, Mr. Buckner?
So if we go to is that the last slide, Courtney? I think it might be. So You know, what the standards were enunciated by the staff, I'd be happy to summarize some at the end of the presentation. If the Planning Commission has any particular questions about the site, we'd be happy to answer them. Again, the layout and the design has already been approved as a concept site plan. So it's a little bit odd to present the same thing twice, although as Mr. Buckmer shared, the requirements for subdivision approval have been added. I would note that the staff report has all the agency TEC approval slips that are needed, with the exception of the DPW one that was received today. My client worked very hard, along with their engineers, to work with DPW through the last week or so to get a final approval from them. That is now part of the record and is on board docs. And again, that was received this afternoon, and we thank them very much for their hard work to get it done for tonight. The one thing I'll note about that is that this is, again, a larger project that has been under development for some time. As part of that, the traffic light that is there at the end of Patuxent Boulevard where it intersects with Maryland Route 4 was funded in construction by my client as well as other improvements. All of those were done as part of the overall development of the woods at Myrtle Point, and these 132 townhomes were considered as part of that mitigation. So that mitigation was done in anticipation and as part of this development. It was done ahead of time. I know this Planning Commission has had concerns in the past with other developers that have either phased their improvements or done them toward the end, or had concerns about needing permits in hand before things were done. This has been up and running for some time. That is the mitigation that was required. I believe there were two other things other than the light itself relating to pass-through lanes and other lanes that were done. Mr. Lenhart can comment on them. But we've worked with staff over the last week to confirm that all of that was done some time ago. So all of the traffic that needed to be mitigated was mitigated some time, and the county's been enjoying the benefits of that even before this development was done. Any of the other sections that you've seen have used this section with 132 townhomes, I believe actually 135, what was the number that was used as background trips for any of those to be approved. So these all have been taken into account on any of your other approvals. So we believe that was the one comment that was not specifically part of the staff report because that was not available when it was prepared. But we believe that today does give us the last piece of information you needed tonight to grant our approval for preliminary subdivision. And again, Mr. Lenhart is here if you have questions specifically about the traffic. He's presented to this commission several times on this project and would be happy to do so again. So again, we're here for preliminary subdivision plan approval. The criteria set forth in the subdivision ordinance, as Ms. Jenkins said, and we believe based on the analysis in the staff report as well as the DPW report today that we meet all of the requirements of the section as shown on the subdivision plat that Mr. Buckmer prepared for you. And everybody is here if you have any questions.
Any board members have any?
Mr. Chairman, I have a couple questions. Mr. Longmore brought up the traffic. The letter that's in the packet from John Groger dated in 2007, is that when the project, Myrtle Point, I know it wasn't the same developer, is that when it started?
I can either let Pat Mudd or Mike address that, but no, I believe the project was underway before that. I don't think that was the first step in it.
Okay.
I was involved before that day.
Second part of the question before Pat or whoever answers. When this letter was proposed, I wasn't on the board in 2013 or 2007. I'm wondering when the traffic mitigation was proposed, how many total units were proposed to be built in Myrtle Point? Does anybody know?
I can, Pat, would you like to address that? Because I know you were involved at that point. The units, these improvements from 2007 account for all the units we're here today talking and that are proposed for the project as a whole is the short answer. Pat, if you want to correct me or have anything to add to that, you might be a good one to answer that.
Pat, did you get a chance to, did you take the oath when we gave it?
I took the oath when you were swearing in.
Okay, I thought I heard your voice, but your face wasn't up on the screen. Okay, thank you, sir.
I apologize.
We believe you.
This project started probably back in the 1990s and has gone through several ownership changes over the years and several iterations of design. In 2007, Section 2 and Section 3 were designed to be 135 townhouses, and it was moving forward. It actually had Planning Commission approval for the site plan and for the preliminary plat. Then things changed. The new developer decided to change his direction. He wanted to build more singles and less towns, so the townhouses got put on hold. And then market conditions have changed again since then, and now townhouses seem to be more marketable than single families, so the plan was changed again to go from singles to townhouses. But consistently all through the project, the original phasing plan for Myrtle Point, which dates back to 2003, I think, had, I believe, 257 total units for the project. And the 80 TDRs that you were talking about earlier is there's 80 more units now than there was when we proposed the 257. So, and that includes what the Planning Commission saw in, I think it was 2018, which was a preliminary plan for sections 2, 4, 5, and 6. And at that time, section 2 is proposed as condos, section 5 and 6 were proposed as townhouses, and section 4 was a recreation area. So this project has a long, long history. The mitigation requirements from the state highway came about when phase 1, section 1 was being developed back in 2008, 2009 timeframe. And as Chris mentioned, the mitigation was a signal at Patuxent Boulevard and Route 4. There was also mitigation to add a third left turn lane at Route 4 and 235. There was also some signal coordination between various signals so they all function in conjunction with each other. There was accel decel lanes in and out of Myrtle Point, and all of those mitigation measures have been constructed and have been in place for a number of years. And actually, State Highways come back and revise the intersection of Patuxent Boulevard and Route 4 so that people could make a U-turn when they closed off the entrance to the road up close to 235. So, like I said, this project has a long history. When the concept plan for Section 3 was approved in 2013, traffic issues were adequately addressed at that time. There wasn't a quote-unquote APF farm at the time, but there was a traffic impact study that was done in 2007 with 135 townhouse units included in it, and that 135 units has been consistently in the background for every project that has come before this board since that time. And so our feeling is, and I believe Public Works agrees with this, is that the mitigation required for this project has been completed and that there is adequate public facilities from a traffic standpoint for this particular section.
My only reason that I raised that is because when it was initially done, it wasn't proposed this many units. I'm just trying to see in my mind if enough mitigation was done to handle the additional trips, I guess, that 80 more units create, since nobody, I guess, since State Highway hasn't looked at this since 2008 and there's been no traffic impact study since then. But you're saying that since the traffic impact study in 07, and I see that there was one, we didn't get it, but I see there was one, everything proposed on lots 2, 3, 4, 5, and 6 was the same things that's being proposed to be built there now.
No, not exactly. I want to let Mike Linhart address the traffic issue specifically, since he updated the traffic report and did the most recent analysis. But like I said before, over time, the mix of units has changed from singles to towns and from towns to singles, but the total number of units allowed in the project has only increased by 80. And that's, I'll let Mike speak to that, if you don't mind.
Okay.
Mike, can you pick up there?
Yes, good evening, Mike Lenhart for the record with Lenhart Traffic Consulting.
Mr. Lenhart, did you take the oath when we gave?
I did, yes, I can do it again if you'd like.
No, well, your voice is on the recording, so.
Okay, thank you. So we did do an additional traffic study in the 2017 timeframe when the additional sections came in for approval at that time. The study that was conducted at that time included the Section 3 as approved background development because it had been previously approved as part of the original mitigation. And we looked at, in the 2017 timeframe, the additional development that was proposed at that time above and beyond what was in the 2007 approval. And it was determined that, and it was reviewed by DPW and by, I believe, State Highway as well reviewed it. And it was agreed that the original mitigation that was prepared and provided and constructed continued to satisfy the mitigation impacts for the entire project. And so it was reviewed in that 2017 application.
And Mike, I can state for the record and for the benefit of the Planning Commission members, the report that was added to board docs this afternoon from Public Works includes as an attachment the Lenhart Traffic Consulting Inc. March 2nd, 2017 letter addressing that. So that is in the record. I believe that report may have been on board docs by itself before and the report was added today. I know it had been submitted before, but I'm not certain of that. But it was attached to the letter we received today from or authored by Mr. Mills at DPW, indicating their agreement that we meet the standards.
Okay.
Can Mr. Mills address that?
Donnie, are you willing to put it or give us any input on that? Were you okay with the 2017 report? There we go.
There he is.
Donnie, did we give you, did you take the oath when we gave it out at the beginning of the hearing?
Yes, I did.
Okay, thank you, sir. Go ahead, Joe, you can ask your question.
Are you satisfied with the 2017 impact report that they presented to you?
Yeah, so the 2017, just to be clear, that didn't pertain to Section 3 per se. What we looked at was that it was included in the background information. That Section 3 was included there, and that's what we were referring to with our research. Really, over the last couple of days, it's been kind of a blur trying to get this done.
Right, so at that point, Mr. Mills, as I understood it, the Section 3 had already been approved for concept site plan approval, so it was included in the background. And if I understood correctly, just for the benefit of the commission and myself, that in reviewing the 2017 report, it was confirming that those additional 80 units would still be appropriate given the mitigation that had already been performed. Is that correct?
from a traffic perspective,
Right.
we were looking at the trip generation in that case, not talking about a any zoning requirement or what they're able to build
Right.
without TDRs.
It was strictly traffic, what we were asking about, Donnie.
Yes, it was included in that, the best we could tell, included in the original 2007, and then again followed through as a background item in the 2017.
Right.
Let me ask Mr. Mills one more question between you, Mr. Longmore, and Mr. Mills about the one entrance. Could you explain when I look at the what's included in here of what's required, it looks like there's generally two, but one for 75, and then it says something about fractionally.
Right.
What's the interpretation of that between you and Mr. Mills? Because it looked to me like there would have to be two.
I mean, I can let Mr. Mills address it from his perspective, or maybe Barry or Mike Lenhart can talk about it, since Barry did the design work. That's really more engineering than mine. But Donnie, do you want to address that first, and then I'll turn it over?
Well, I think you're really referring to a subdivision regulation, and we don't get too deep into that ordinance. So I think that's, and if you notice, well, it's probably not said on that record plat that's being circulated here, but all of the roads within this subdivision are private. And they're not for these types of townhouse developments. That's typically what happens, is they're private and not a public road throughout the subdivision.
But you're going to take them public roads over once it's turned over, is that correct?
Not these roads.
They'll always stay private?
Yeah, these are not slated to come into the county system.
Okay, well, then I guess my question goes more to Mr. Longmore. Then I can't find where it says that, but it talks about 75. It's somewhere within the first few pages, but.
Chris, can I address this?
Sure, Pat. Jump in.
Again, this is history. Going back to when this plan was first going through initial reviews, we negotiated with the Department of Public Works, John Grover at the time, to come up with a single entrance plan that Public Works felt would be adequate for emergency vehicles, for ingress and egress in case there was some issue within the subdivision. And the plan that we came up with was to have two 20-foot lanes coming into and out of the section, as well as a 40-foot grass median between them, and a roundabout when you get to the end of the entrance road and into the subdivision. And the thought process was that if there was an accident on the entrance road, that traffic could be diverted to the other side. And that if emergency vehicles were necessary for the incident, there was room on the median and on the shoulders that they could be accommodated without shutting down the interior project in its entirety. And then having the roundabout, which is a mechanism that is used to reduce traffic conflicts and accidents, was the focal point of the intersection, so that you'd come from two different directions inside the subdivision and still would be able to get in and out without, even if there was some closures. That's kind of the history of how this entrance was developed, and that's the way the plan was developed since then.
But I was specifically talking about these 132 townhouses, or it wasn't. I mean, it's in this plan where it talks about a a sufficient number of ingress and egress. So I guess my only question, since it's going to stay private, it doesn't matter, or it looks to me like because it's more than 75, it would be fractionally required for two, or is that, am I reading that? I may need something either from you, Mr. Longmore, or from Mr. Murphy from the county. I'm not sure, what that means.
I mean, Pat, I believe that's what you're addressing, right? That in working it out with Mr. Groger, that the way I understood it from when you went through that years ago was that functionally this is the equivalent of two separate entrances because of the width, because of the median, because of the roundabout. And I know there's, as I recall, some slopes and other things that made this entrance the appropriate place to come into it, that by designing it that way, at that point, that was an acceptable design. Did I understand you correctly?
Yes, that's what was negotiated. And having the two 20-foot wide roadways, one in, one out, and a 40-foot division between them of grass, you effectively have two full-width roads to county width requirements as egress and ingress and egress. And the project is surrounded by very steep slopes, stream valleys, no other access points that were really feasible, and so that's how this entrance was developed and done in cooperation with the Department of Public Works at the time.
Okay. So it was hard for me to see it on the plan. So what you're saying on the plan is it's 20 feet coming in, 20 feet going out into this 132 townhouses.
Correct.
Okay. It was hard to tell exactly how wide it was on the
On the record plat, right?
Yeah. Okay. Thank you.
I just wanted to point out that you're reading it correctly, that typically you would have two entrances for 135 lots or 32 lots.
Okay.
That's all.
Thank you very much. And thank you, Pat.
Thank you, Donnie.
Yep. Thank you, Mr. Mills.
Mr. Evans?
Just a quick question, Pat. I know historically, you mentioned runoff and the rest of that. Has all that been addressed now with this project? I mean, for a long time, we were back and forth, and I know that the developer and DPW were round and round for a pretty good while. So have we squared away with all the runoff and that? I don't see any folks out here tonight. Historically, place would have been full of people. So are we good with all of that, Pat?
I think we are, Merle. The plan that's been approved by the agencies for the site plan includes 28 microbiome retention facilities.
Yeah, sorry.
So a lot of water is being infiltrated into the ground before it leaves the site, and then the water that does leave the site is going into the existing stream valleys, and because it's being pre-treated, the peaks that you would anticipate from a storm runoff are mitigated, so the peak runoff doesn't hit the stream at the same time as the water from other developments or other storm drain system. It's mitigated and comes out over a 48-hour period after the rainfall events. So, theoretically, it shouldn't increase the any kind of runoff issues downstream.
Yeah, and typically. Thank you. And typically I ask questions that I have some answer to already, but sometimes they need to be asked, so that people get the benefit of that. So just one other real quick question. Are TDRs hard to come by? Anybody?
They can be difficult. I will say that my client has secured the 80 TDRs they need already for this section. So
I guess what I was getting to, will he be able to secure them, or will there be fee and lieu involved in that? Or
I believe he secured, and Mr. Rathflub is here, I believe he secured almost all of them except for a handful, and he might have done a fee and lieu because of that. But he has some others that are available that there's a title issue or something, so he ended up doing the fee and lieu.
No, that's fine. That's fine. Thank you. That's all I have.
Any other questions from the board?
I got one more question since it's like it's going to wrap up. Are the sidewalks, where do they go? All the way out to the road?
We can pull up the,
Because like I said, it's so hard to tell on the, when we look at the.
have that on the subdivision plan?
It is not on the subdivision plan.
Yeah, it was on the approved concept plan is where,
That's correct.
where they were. So I don't know that we have the concept plan here. Pat, do you have a recollection, or can you share that for Mr. Van Kirk?
Well, I can tell you that there are sidewalks on both sides of the entrance drive, and they both go down to Patuxent Boulevard. And there's sidewalks throughout the subdivision. There's a sidewalk that runs down, and I believe is going to connect to the sidewalk that is in place at the entrance to the pool and the clubhouse. So there is pedestrian access on a sidewalk adjoining Patuxent Boulevard.
Let me ask one more question along with that. I know we spoke at it at the 2018 and 2020 meetings about the other sections, and I know it's gullies and hills and ravines and stuff. I think this lot is right next to the pool and clubhouse, is it?
It's adjacent to, yes, that's correct.
Is there any possible way, since it's so many townhouses, so that people don't have to, I don't know what's in between it. I know we've talked about interconnectivity before, with a path or sidewalk. I mean, 132 units is going to produce a lot of kids that won't have to go up to Patuxent Road, go down the road, and then walk in. I don't know how far it is or what the terrain is right there. Is that a possibility that we could talk about? Or, I mean, I know hadn't been done anywhere else because it wasn't really feasible from any of the other lots that we had talked. I know this has came up before.
Well, the street elevations inside of Section 3 and the differential between them, the ravine that runs between Section 3 and the clubhouse, and then getting back up to the clubhouse itself, there's probably 80 feet of elevation difference going down and another 60 or 70 feet coming back up.
Okay, I wasn't sure if it was relatively flat, but again, it's more ravines like in the rest of the.
It's pretty severe.
Okay, thank you.
Yeah.
That's all I have.
Any other questions?
I guess I'm curious about what's happened, considering that we hadn't had an evaluation on what's going to happen to schools, impact on schools. Has there been any issues that have been caused by an expansion of a development like this with our schools? I guess I'm asking the board now. I mean, I don't know who to ask.
Mr. Hunt, I believe, is stepping up.
I can answer your question by saying that there hasn't been an in-depth examination of that. We have the next capital facilities plan from the school board coming April 24th. Ms. Jenkins did go back and look at what we had for the concept site plan, but which was adequate back then, but we haven't done the research to see if that's still the case.
Okay. Have we seen any developments actually impact the schools in a significant way?
Without trying to split words too heavily, haven't seen one, have heard of them coming that do, not in this particular area. Different development that has been discussed that would, based on preliminary communication from the Board of Ed.
What type of mitigation happens then?
Since nothing's been submitted, there hasn't been a formal review and there hasn't been a formal determination. Or I shouldn't say formal, any determination.
Roger that, just, okay.
And there will, like all concept site plans, this will be subject to final site plan approval where the APF will have to be finalized through Mr. Hunt's office. That has not happened yet, and schools are part of that. I will note as well that the county has a growth policy that they enacted when school seats were really a concern. It's been suspended at this time. They could reinvoke it later, but it hasn't been that I'm aware of. That's a county commissioner function.
Roger that. We do have capacity issues around a lot of our schools, so I'm just kind of concerned.
So as part of the TEC and subdivision process, the schools did review this, and the only comment they had on the subdivision was regarding the bus stop and whether it was shown on the site plan. So at that time, there was no question about capacity anyway.
Are you referring to the comments from Kim?
Yeah, those 2013.
Yeah, 13.
Letter. That I think is part of the staff.
Kim Howard.
Kim Howe, yeah, there's, her comments are here.
Right, and we have reached out to the Board of Ed this afternoon, but again, I've not heard back from them yet, so we don't have a planning director's report ready for you to approve this evening.
If we were to approve this evening, Mr. Hunt, was that something we would have to put a condition to be on us for a safeguard, that just the Board of Education would give its?
I believe the way that the ordinance is written, that you cannot delegate that to the planning director because it's a major subdivision.
Mr. Hunt, am I correct that the site plan cannot receive final approval unless you determine they're adequate public facilities, including schools?
That's correct.
Thank you.
So if they're not adequate schools, the site plan would not be finalized, and therefore the subdivision could not be recorded. Is that correct?
Now, that I'm not sure about, because there's a sequence question that's in what you just said, and I'm not quite sure what would happen to the subdivision.
But let me rephrase it then. In order to build these townhouses and get them subdivided, they would need both final site plan approval and final subdivision plat approval.
That is correct.
Okay. So there is that provision that would prevent it from going forward without school seats.
That answers that. Thank you. Okay. Anything else for the applicant?
The only comment I wanted to make was that a couple of us were young enough then, sitting there along, I think you were too, Mr. Chairman.
What you're talking about?
And that's why we had put the growth rate in there capped.
Right.
And what we're hearing now is that the reason that it was removed is that the 1.5 has never been exceeded. And that would do the impact on your school systems. But if it comes to that, then the school's budget runs right along with the 1.5% increase in the school budget to take care of the adequate public facilities. And I don't think there's anything, no report that says that the growth rate in the county has been beyond the 1.5%. So that being said, that's the reason that you don't need your 2% cap, because the growth rate has never been reached. But that was the reason we had that 2% there, was back in the day when there wasn't enough schools and it wasn't adequate, and then we had to do the queuing process.
Right.
And then each subdivision was only allowed a certain amount of seats that was made available at that time. So part of the trigger mechanism would be if it exceeded the 1.5, and maybe you could address that. You were with the Board of Education, because that's their normal growth rate cap is 1.5.
Yeah, and I recall that as part of, Pat was involved in that too on Section 1 of, I believe it was Section 1 is what it was called, Pat.
Right.
That was a big issue with this development in the beginning, is when that was, they were in the queue, they were allocated lots each year, or each, I think it was per year at that point.
So the Board of Education will, during the process, will report whether there's adequate seating available at that time. And if there's not, then you won't move forward.
Right.
Let me ask a follow-up question to that so I'm clear. Mr. Hunt made a statement that, and I've read it in here before, typically the planning director does the adequate public facilities report. In this case, since a preliminary report on a major subdivision, the planning commission has that approval or disapproval in this particular case where we normally don't. So what was the exchange between you and Mr. Hunt when he was saying that since he don't have the final say over that?
So because it's a what I was suggesting is because it's a townhouse development, it needs both final site plan approval and final subdivision approval. Townhouses are the only type of developments that need that. In order for this project to receive final site plan approval, Mr. Hunt, as the planning director, has the final decision as to whether it meets adequate public facilities, just like a commercial project, a site plan like that, or others, or a condominium project for that matter. So for the subdivision side of it, this board decides of whether we meet adequate public facilities now. For the subdivision, for this project to go forward, we got to meet both. So there's 2 checks on it instead of 1, as it would normally be, is what I was discussing with Mr. Hunt. So we prefer to go forward. We believe you have enough to show that at this point it does meet adequate public facilities, but if there's a concern as we move forward in the process, there'll be 1 more check by Mr. Hunt and his final site plan approval to determine whether it's there.
Is that the only thing we're lacking, is the Board of Ed? You know, I think you said DPW&T did theirs.
Right, so if I can just intervene and also answer your question as well. You're right, typically for major site plan, y'all would approve the concept site plan, and then when it goes to major, then Mr. Hunt reviews the APF and makes that determination. But it expressly states in the subdivision ordinance for major subdivisions, the planning commission is the final determination for APF. And then it would also, there's a major site plan, then he would be looking at that APF form at that time as well.
Right, so I guess my question is, what's lacking right now of the 5 or 6 things?
Well, we just received the APF form this afternoon, so
Right.
Mr. Hunt hasn't had a chance to thoroughly review that as well. And I've started drafting the planning director's report. And so, yeah, basically the major remaining item is for school capacity, but also for him to look and review the APF form as well.
I mean, it says state highway, they don't have anything to look at as far as this, I'm going to assume, or Metcom?
And I will note that the subdivision plan that you're here reviewing tonight did go through TEC. Board of Ed's included in that, as well as the other agencies. There's no negative comments from any of the agencies.
Yeah, but it went through TEC in 2013.
No, there was a more recent one for the subdivision plan. I believe it's in the staff report.
Okay.
It was August 25th, 2021.
Okay.
Was the TEC meeting.
It didn't go to TEC on August 25th, 2021. That was a typo. I corrected it for the
2013.
PowerPoint. Yeah, it was 2013.
Okay.
Brandy looked it up.
Okay.
Also,
Mr. Hunt, I think, wants to speak.
I just wanted to say, with what Ms. Jenkins is saying, we have looked at what would have been, or what is actually, the draft director's report, finding of adequate public facilities for the concept plan. And because there has been a passage of time between when that draft was prepared and the situation in the county may or may not be the same, that we would have to, or we intend to, and we will contact the Board of Ed and see what we need to do to be sure that school capacity is adequate, even though the concept plan was passed some time ago. See if there's anything changed that may change those preliminary numbers to be sure that that's right. Mr. Longmore, I think, is saying that the numbers that I look at for APF are going to be the same numbers that you're going to look at for the director's report and APF for the major subdivision, because they're really one of the same when they come together. It's just at this point, I don't know, I can't say for sure that we have everything for the concept site plan to go to the major subdivision to be approved because of the passage of time and wanting to be sure about the school figures. What we got today from the traffic we haven't really looked at, but Mr. Mills evidently has looked at it sufficiently to be able to send his letter, which says that mitigation has been performed and everything is as it should be. So that's not going to be an issue so far as I can tell tonight. So the only thing that I have a question about is school enrollment, just because time has gone by, and I want to be sure those figures are right.
So the other issues listed, I guess the only reason I'm asking this question is there's 5 things listed that would be included, that it says the following items are needed to prepare the planning director's report. You already talked about DPWT, then it says SHA approval. I'm assuming with the traffic, that's been done quite a while ago. Then it's got 2 METCOM approvals for water and sewer and fire suppression. And then it's got the Board of Education. So has METCOM looked at the APF to see if it's meets them, or they haven't got to that point yet either?
You could ask Mr. Balkin that. I wouldn't want to answer for them since he's on the line.
Okay.
Yeah, METCOM doesn't normally look at the APF.
Okay.
But I believe, like you said, you have my approval of this, and we've already approved the site plan also.
Okay. So it gets back to all we need is BOE.
That's how I understand it.
Okay, thank you.
Do we need BOE for tonight, or is that later?
This is it.
It's one and the same, because, as Mr. Longmore said, the major site plan is approved by the planning director with respect to the director's report and APF. But the major subdivision, which is what this is, has to be approved by the planning commission and can't be delegated to the planning director for that, even though the figures will be the same.
Honest to God. I have a question. You reached out to the Board of Education? When? Do we know when you reached out?
Tonight.
No.
I mean, late this afternoon, because that's when I...
This is not a vacuum. They knew this was coming. They knew they had to participate. Why haven't they done that? I'm not asking you to speak for them.
Right. I mean, they did send some comments about the bus stops, but what Mr. Hunt has alluded to was, as far as when we prepared the planning director's report,
right,
we're supposed to calculate what, it's like a math problem of like a percentage for 132 townhomes, how many students could, or will likely, will it create for elementary school, middle school, and high school.
So let me say,
and if you take that number, sorry.
Let me ask this differently. Kim Howe is really good at numbers.
Mm-hmm.
I mean, she's exceptional at them. So my question is, when was Kim made aware that we're having these proceedings tonight, and why haven't they responded? I mean,
yeah. Again, because there's been such a long period of time, and it's been at least 2 years since one of these has even been done. We're not sure if the existing capacity numbers that we have are accurate.
But Kim knows. Guarantee you Kim Howe knows.
Right, and I'm not disputing that she doesn't know. It's just that as staff, we don't have those numbers. And this is the first time that we're preparing this director's report. Typically, it was Mr. Chapman, who is retired, so we're not sure if the capacity numbers that we have are currently accurate. So we are reaching out to them.
Somebody else answer that question differently.
The last time she responded was 2013 when this came up.
Between then and now, she should have responded again. Why hasn't she responded?
She wasn't asked.
Well, that's the question I'm getting to.
That's what he's getting to.
Exactly.
I just said that.
I'm not sure if she was sent the plans when the plans came in. All I know is that we need those updated numbers, and
Chris,
that's
let's
what
make
we're
this your
working
fault.
on now.
We'll make it your fault. Did you?
I'm not saying it's anybody's.
Did you reach out to Board of Education?
We did not. The first time we were made aware, we weren't aware this was an issue until this hearing started tonight, that there was an issue with the schools. We knew there was an issue with DPW and roads. That's why we worked really hard over the last week to make sure that report got to you. And again, we appreciate all the work that DPW and T did. If we'd known this was an issue, we would have reached out and asked them. We had the concept site plan approval is approved. It's been extended. It has an APF requirement as part of it as well.
If we're to make the APF decision tonight, then the school system should have answered it, or staff should have asked Board of Education, is there an issue with this? Because you're asking us to make the decision tonight, and we don't have the Board of Ed, and nobody's reached out to the Board of Ed to ask that question.
All right, well, we got two options.
And again, this is a report that generally was done by a staff member who's no longer with us. So once we started putting it together, that's when I started thinking, well, these numbers could be really old and outdated. Maybe we should reach out to them. We didn't even realize we were going to get a signed APF form for this evening until 4:30 or 4 o'clock this afternoon.
Well, then
People
then we
come and
shouldn't have
people
gone forward.
go in your staff. I mean, but somebody can pick up the phone or get a piece of information to the Board of Education.
Again, I'm not blaming anybody. I'm just
Smoke's coming
stating
out of your ears, Ms.
the
Evans.
fact of, I didn't have the knowledge, I
get
guess,
that.
to know that, to reach out to them in advance.
I guess the frustration is that we're here, they're there. We want to make a decision based on information provided to us. We don't have the information. And I'm not trying to blame anybody either. I mean, I don't know who did it or who didn't do it.
I'm not saying.
Doesn't matter to me. I don't care. I mean, I want to know.
We don't have the
We don't have the information. So let me ask you this. How long will it take to get that information back and for you guys to formulate this report?
I'm sure we could put it together fairly quickly if we hear back right away.
It shouldn't take long. One of the things that I hope you'll take into consideration is we were not aware that we would have sufficient information to even go forward as far as we have tonight until late this afternoon. We were thinking that without the traffic, this wouldn't go like this. Then when we tried to do our part, which was late in the game, you would say, and looked at the Board of Ed and the date of the material that we were looking at, and then knowing that there's going to be an update in the next month from the Board of Ed, I thought it was prudent to say, I don't really know that I know enough to be able to say that there's going to be adequate school capacity to be able to answer Mr. Thompson's question, which is it adequate as of tonight? And I don't know the answer to that. How long it takes to get that? I don't think it takes it very long, but since we haven't done it, I don't know for sure.
But can you understand the frustration of this?
No, sir, not really.
No, you really? You can't understand why we're here, we can't make a decision because we don't have the information, Bill?
No, sir.
You don't see how that's frustrating?
Because, sir, if that were going to be the case, when you got the traffic information today at 4:30, I would have thought that would have been a reaction that the board would have had with regard to, we're just getting that tonight, 4:30 for a meeting tonight, which had nothing to do with land use and growth management not providing the information. We didn't have it.
Bill, I'm not interested in blaming anybody. I'm not interested in blaming anybody. I'm interested in trying to move this forward. That's what I'm interested in. If that's what we're going to do, that's what I'm trying to do. I really don't, I'm not interested whether or not you didn't contact, but we don't have the information. And here we are.
Can I make a recommendation that we can't move forward until we know what that is?
Well, can't we?
Mr. Murphy, come up here and let me ask you another hypothetical question, sir. Seems my forte.
Can't we slide this forward a week or two?
Blue. It sounds to me like I have two options. One would be, and let's just say that we're in the approval part of this, or the approval mindset of this. Could we make a motion that has to do with if adequate public facilities letters are received by land use and growth management, that this could pass along with the requirement of the TDRs and such, or should we just continue this until the next available continuance hearing date and have everything in front of us? What's your opinion?
So the language of the CZO says that adequate public facilities are adequate, and I don't know if you can make a conditional. It's tough to say.
That's why you're making those big dollars,
I
sir.
know everybody's here and wanted the information.
Well, I mean, it's our job to make a decision based on that information.
And if you don't have the information, I'd like to say that you could, but I hesitate to say that you can make that information on, or make a approval decision contingent upon information.
But you're hesitant with that. That's basically that's all I need to hear.
Sure. I guess my next question would be to staff as to when the next meeting would be. If it's
We could do it on
That's what,
next meeting.
April 11th.
I was just speaking with Ms. Glenn to see if it would be possible to do it earlier than the next continuance date, since we've already presented everything except for this decision. I believe, in talking with her, that March 14th might be available for
Could do that, because if we get through everything tonight, now, I would like to go ahead and open it up public testimony since we're here tonight, and if somebody wants to comment on it, it'd be good for the applicant. I mean, this is not only is it hard on the board, it's hard on the applicant also. So we're trying to work with both sides. So let's go ahead and move forward with our public part of the testimony after we finish grilling you, Mr. Longmore, and then we will, after that, then we can, I'll go back to you for your part of the rebuttal. If you want, then we'll go ahead and do it for the next, which I hear is March
14th.
March 14th.
Let me ask a question before you decide on that date. Mr. Hunt mentioned when he was speaking that the Board of Education is in the process of compiling whatever they're going to compile, like within a month. Will we have that info by March 14th, do you feel, or you don't know?
Kim will have it tomorrow.
Kim will have it when you call.
Okay, I'm just,
They're going to present the investment.
And look, if we don't have it on, we would ask to be moved to the next available hearing if possible, and if the information is not there, I'll show up and we'll have to continue it again. But if we could go to the next one, if that's possible, since we, have been here tonight.
We're at that part then.
Right.
I just have one, I want to, if I thought I heard you correctly earlier. You said Mr. Hunt makes the final decision on whether or not it meets all the criteria for health, security, the 5 areas.
Yes, because,
Situation.
well, there's 2 approvals we need. One is subdivision approval, one is site plan approval. The way our ordinances are written, Mr. Hunt makes the final APF determination for the site plan part of townhouses. The Planning Commission makes the same decision for the subdivision side of townhouses. It's an odd structure in the ordinance. So what I was suggesting is that with the information you have in the staff report now, there are comments from the Board of Education. The last comments were 2013, that we were hopeful that you would be able to grant final subdivision approval, knowing that if there is not adequate school capacity, Mr. Hunt would be the gatekeeper for us to get the second approval we need to actually build the townhouses.
That's what I thought.
So the project will not go forward if there's not school capacity.
Correct.
The question is whether the commission tonight is comfortable with the information in the record that we've met subdivision approval, because the subdivision means nothing to us if we can't build it out of the ground and build the common areas. We need both to move forward. So there's no practical risk, I don't think, in going
So
forward.
we could make a motion tonight to move forward with the project because it's going to be done by the director to make sure that APF has been followed.
Exactly.
I believe practically that is absolutely true, because this is a townhouse project. If it were a single-family project, we wouldn't have Mr. Hunt as the deciding factor at the site plan side of it. And at that point, you'd be the final determination. There's two decisions for APF that need to be made. One is this planning commission, one is Mr. Hunt, since they're the two tracks. And if I'm wrong, staff can correct me, but
So, therefore.
You would just have to be comfortable that you're pretty comfortable with what the numbers are going to be from the school board.
Right.
And to me, if there's two checks and balances here, why would we put something forward without all the information? And the reality of it is Ms. Howe will have charts in a book that tells her current enrollment, capacity, projected enrollment. It's easy. She can figure it out pretty quickly. But as a person who opened an elementary school that was over capacity at one point, it is critical to know that information.
But they're all over capacity.
I opened one the day,
I know.
day one,
But
over
that's-
capacity, so.
State requires it.
State won't let you open unless you're over capacity anyway.
Yeah, but still, when you have to
I
bring
get it.
trailers in, yeah.
Yeah, but they don't want to hear that because it's, you have to look at it from a holistic perspective versus, because they would say to you, Hollywood Elementary School has plenty of open space. I'm serious. Although Leonardtown, Evergreen might have to bring in 10 more trailers. It's a concept I just can't
Yeah,
put
but
my head
the
around.
county doesn't recognize trailers as capacity.
And we don't count pre-K, I think, in our enrollment
Right.
numbers.
Yeah, there's a whole
Charles
lot.
does, but we don't count them as capacity.
Okay.
We're getting off.
But enough, we're getting off on
Yeah.
Yeah, but
Let's get
all
back,
about school.
let's get back to the arrow here.
if there's supposed to be two, our group and Mr. Hunt's, that approves it, why would we approve it without all of the information?
Okay.
Just continue.
And with that being said,
I agree.
Just continue it.
well, we're going to, but we're going to go to public testimony.
Oh, yeah, right. I'm sorry.
So,
And then I'll step back up, request to continue.
all right, at this time, I'm going to go ahead and open it up to public testimony. You want to call and see if we have anybody that's stayed up?
Planning Commission public hearing.
Hi, Ms. Wood. Do we have anyone on the line that wishes to speak regarding Woods at Myrtle Point, Section 3?
No, we don't.
Okay, thank you.
You're welcome.
Okay, and there's nobody in the audience. Okay, we're going to go ahead and close public testimony. Chris, just come on back up here. Let's do it. I want to do it the right way. At this time, because of the information, do you have a request?
We have a request to continue this hearing until March 14th at 6:30 PM in the Chesapeake Building here in this room. And at which point we will work with staff to make all efforts to have the information Planning Commission has requested about the school seats.
And also, we're going to need that night for the APF is from the school board, correct?
From the school board, yes, and that's what.
So I want to make sure that's all we're going to need to hear that night
Right.
is information on that. Everything else has been taken care of. Okay?
Thank you.
Okay. I have a request for continuance to March 14th. Can I have a motion for that?
So moved.
All right, well, I'm on.
Second.
Okay. Motion's by Mr. St. Clair, and this second is Mr. Evans. And that is for March 14th. All right, voting on the motion.
Quick
Mr.
discussion.
Excuse me?
It does say 6:30 in the Chesapeake, but I think it's supposed to say exactly like Mr. Longmore said, where it is and when it is does the motion.
Okay.
Correct. I mean, I think they were saying so moved is what Mr. Longmore said, just to make sure that it's in the.
6:30 on March 14th.
Correct. Here.
Yes.
Okay.
And, all right. All in favor of the motion, Mr. Hall?
Aye.
Mr. Van Kirk?
Aye.
Ms. Summers?
Aye.
Mr. Evans?
Aye.
Just check. Mr. St. Clair?
Aye.
Okay. Ms. Roebuck?
Aye.
I also vote aye. Okay. We'll be back here on March 14th. Clean this up, okay? Is there any other business this evening? Motion to adjourn?
So moved.
Motion by Mr. St. Clair, second by Mr. Evans. All in favor of the motion, say aye.
Aye.
Okay, thank you. We're adjourned.